Item number 5 of today's daily list also. What is the prayer? Your Lordship, can the matter be adjourned for the day, Your Lordship? Actually, SI was to appear, Your Lordship, but she is not well today. We are not passing in this, or at least let the matter reach pass the order. Okay, Your Lordship. Let's. May I please proceed? I beg to mention item number 10, Lordship. Yes. My senior out of station, Lordship. So kindly, Lordship, may let the matter next week. Let the matter reach. That's it. Let the matter reach.
May I please, Your Lordship, I beg to mention item number 14. The matter may be adjourned for 3 weeks. My senior is out of station.
Let the matter reach.
Okay.
I have to mention item number 7. Madam. This
Yes.
matter may be adjourned for today, madam. My senior is out of station. Madam.
Wait for your turn. Let the matter reach.
After 1 week.
Yes. All the items.
um,
May it please your Lordship. Lordship, this is a contested case and the petitioner was declared to be a foreigner of the stream 1966 to 71, Your Lordship. And documents were there. However, that is not the contention. After the order was passed, Your Lordship, the petitioner has also registered himself before the FRRO and he is waiting for the period of 10 years to elapse. The only thing before Your Lordship in this petition is that he had adduced the witness of DW2, Your Lordship, the oral evidence, an elderly person of that locality who has deposed that the petitioner and his father were present in the village, Your Lordship, prior to 1965. So that was not considered at all.
Will that be sufficient for the to prove your citizenship?
No document was there, Your Lordship.
Then-
Admittedly, Your Lordship. No document was there.
Will
But
that be
whether
enough? Will that be by giving some moral evidence of someone within the locality? Will that be enough? So us
Lordship,
that kind of evidence is acceptable while
Lordship,
proving the citizenship.
the DW2 is at page 25.
You understood that DW2 has given evidence in your favor.
In my paper.
Let us see in your written statement.
Written statement is annexed as page 13, Your Lordship. Annexure 1. Para 4 at page 15, Your Lordship. In the 1970 voter list, their name was enlisted, Your Lordship, but they have stated that they could not enlist their name in 1960 prior to 1966. Your Lordship.
Read paragraph.
That it is submitted that since the financial condition of the parents of the opposite party does not permit them to purchase any landed property, so they
No, paragraph 2 of your written statement,
Paragraph
page
two.
14.
the opposite party is not a foreigner as alleged. His parents were being people of Indian origin as per section 6A of Indian Citizenship Act due to severe civil disturbance and religious persecution prior to the commencement of India-Pakistan war during the year 1965 were compelled to take shelter in India from the erstwhile East Pakistan. The parents of the opposite party along with the opposite party who were minor child of about 5 years of age along with other
So
families.
this is a clear admission
It's
that,
an admitted fact, Your Lordship.
so if you have entered India
Yes, Your Lordship.
after the partition and independence, what is the procedure to be followed? You just simply can enter India and take over government khas land. You have admitted the fact that you have taken over government khas land.
We have purchased a plot of land and moved there subsequently.
That is a different issue.
We have annexed that
You have
document.
taken possession of government khas land, started doing something else therein. Tell us. If somebody gives an evidence, yes, he has come from East Pakistan or Bangladesh, that was not Bangladesh at that point of time, East Pakistan. And the occupying land was my neighbor. Will that prove you that you are an Indian citizen?
Not necessary. Lordship, what I submit now, Your Lordship, as I have
That
already.
DW2 has clearly stated you have been residing therein since letter session prior to 1970, or say from 65.
Lordship,
What is the citizenship access?
he has to get himself registered as Indian citizen.
You have applied for the Indian citizenship.
After passing of the judgment FR
So-
station.
You have entered India, maybe prior to 1965 war, India-Pakistan war. But even at that point of time, there was a provision how to enter India. Why not you are an illegally entered India? Why is the illegality in India at all? Only because on what basis the evidence of the DW2, the oral evidence of DW2 should be accepted? Only because of saying something that he was residing with as my neighbor with his father. Is that enough?
Lordship,
Under section 9 of the Citizenship Act, what is the procedure to be followed?
yes, Your Lordship.
How do you prove your citizenship?
The burden is upon him. Your Lordship.
Then what kind of evidence you should leave to prove your citizenship? Entire burden is on the proceeding.
On the proceeding.
You can bring anyone. Even from East Pakistan, you can bring someone to give your evidence. Will that prove you that you are an Indian citizen? Tell us.
At this stage, Your Lordship,
We
maybe
are not considered at that respect. Who you have to place your entire fact before the tribunal and to prove your citizenship under section 9,
yes, Your Lordship, that is true.
right? Now, by placing DW2, the oral evidence, is that enough? The proof of the citizenship?
Lordship,
Why, what was the reason why the Honorable Apex could consider the legal documents? What are the documents to be considered for the purpose of citizenship? If a person is found that he has been alleged that he is not a citizen of the country, it's required to prove these documents.
documents, sir.
So.
In 1971 onwards, there are documents. Now I
that
submit,
is
Your Lordship.
1970 on, that is
I
something else.
understand, Your Lordship. So, Lordship, as I have already registered myself at this stage, I can take instruction whether this is infructuous or not, because ultimately he has registered himself and nothing will survive. So, sometimes some accommodation I can withdraw it.
There are certain cases, Mr. Payang, you'll be knowing. During this kind of exercise earlier, while with Justice Goswami, as he was then, we have found many such cases, people entering India from this Pakistan. And there is a thing we have to have seen. First, they will come, say, undivided Kamrup. Right? First government land. It was not occupied as in today. There's lots of barren lands are there. They used to occupy, then used to shift. from one place to another. When they do exercise of numeration of this voter system, they used to shift from one place to more interior places. Say from Hajo to some internal parts of the Nalbari. There are 2-3 judgments in that regard, because even now you'll see most of the cases, there is shifting tendency of these people from one place to another. Suddenly they will shift. When they have agricultural freedom, maybe occupied government land, but they shift themselves because so that they don't have to go back from their original place.
Yes.
There are 2-3 judgments rendered earlier under those circles. Tell us, Mr. Counsel.
In the meantime, Lordship, I'll take instruction whether I can withdraw this or not, because ultimately he has registered himself, nothing will survive.
Check, at para 2, it is your own admission.
Admission, Your Lordship, that is an admitted fact.
Then-
that the entire family came to India. Only the period of 65 and 70, that is.
And that's why you have been asked.
Yes,
You have been considered as a foreigner for that period only.
Lordship.
And then that is already there. What you have to do, you have done already, you have applied for.
Yes, sir.
Where is the illegality? Your own admission. When?
Lordship, after 2 weeks. After 2 weeks, Your Lordship, I'll take the instruction.
Give us a date.
After puja vacation, any date, Your Lordship.
Why before puja question? What is the
Before
necessity?
puja, then Lordship, on 10th or 11th.
Okay, they come. Heard Mr. B.J. Mukherjee, London Council, appearing for the petitioner. NMS LDB, London CGC, for the response number 1, and as standing council, state coordinator in RC, response number 4. Also heard Mr. J. Pine, standing council, Home Department, for the response number 2, 5, and 6. As well as Mr. A.I. Ali, standing council, election commission, response number 3, and Mr. P. Sharma, government advocate Assam, for the response number 7. On being referred by the Superintendent of Police Board under Rule 2, within bracket 1 of the Foreigners within bracket Tribunal bracket Close Order 1964, as to whether the petitioner, the foreigner from Bangladesh who entered into India after 25/03/1971 or not. The Learned Foreigners Tribunal number 1, Bongaigaon, Assam, by its order/opinion dated 27/12/2019, after considering entire aspect of the matter and hearing the parties, found the petitioner to be a foreigner of the stream between 1966/1971. Appointed the petitioner is a subsequent. Accordingly, on instruction, Mr. Mukherjee and council for the petitioner submitted that the petitioner has already applied for registration of his citizenship.
That is annexure 7, I have annexed also. Page 32.
On 06/02/2020. To that extent, the petitioner has annexed copy of this application for registration. The next step. However, the petitioner is aggrieved as the learned tribunal, while considering, while opining by the Universal such and such, did not rely the oral evidence of the DW2. That the petitioner and his parents came to India from Pakistan prior to 1965 and settled at Borpakra village. The petitioner, in his written statement filed before the tribunal, admitted the fact that due to severe civil disturbance and religious persecutions prior to commencement of Indian-Pakistan war during the year 1965, they were compelled to take shelter in India from erstwhile East Pakistan. And along with other family members, settled at a remote village, Borpakra, under Bijni police station of erstwhile Gwalior district, now Bongaigaon district, and occupied a government khas plot of land. From the perusal of the opinion of the tribunal, it indicates the petitioner failed to prove his citizenship as required under Section 9 of the Citizenship Act. At this stage, Mr. Banerjee and counsel appearing for the petitioner, sorry, Mukherjee, prays for some time as to whether to obtain necessary instruction as to whether petitioner refers to express this petition or not, as he had already applied for registration. To which the counsel for the respondents have no objection. Prayer allowed. List on 12th of October.
Please, Your Lordship, can you pass over the matter for a time being, Lordship?
We're in the midst of a hearing, so we don't know whether we'll be able to take it up on part person.
Yes, Lordship. Lordship, similar fair item number 2, Lordship. Yes, Lordship.
Please, Lordship. This present appeal is directed against the single bench order 336, Lordship. This, with regard to the post of director in the Regional Institute of Medical Sciences, that is ranged at Imphal. And the vacancy, there was unanticipated losses has arisen only because of the premature repatriation of the then incumbent, the regular director, who was initially appointed for 5 years lawsuit. And before the completion of 5 years, he had to be called back for so many reasons. So then there occasion an unanticipated vacancy. Once that unanticipated vacancy arises, then the rule says, bylaws of the Reams, 12.1.3 says, like the law cadre or the director is the professor's post also. And the Senemos was to be given the additional charge to look after the post till such time the regular director is appointed or whichever is earlier. Then the present respondent, initially he was appointed. In the available list also, his position was the third by the time.
The rule of the Reams says that it is with the senior most person.
Cinemas. Then somehow the ministry has appointed, the present appeal is preferred by the Ministry of Health only. So initially he was appointed. Then the present private respondent here in the present appeal made a petition before the High Court, and the High Court saying that some senior persons have been overlooked. The cases of some senior persons have been overlooked, and while also accepting the position that by then the seniority position of these professors in Dreams was not finalized by that time. But the available list that was in use, there was in vogue for the last 6-7 years. There was put to use laws by the ministry.
Now, nobody has challenged that list.
Nobody has challenged the list so far. Then after that, after the filing of this case, initially by the present private respondent, Priyosiki, Dr. Priyosiki, then the then single bench has ordered that some cases of the senior persons have been overlooked, and it can be done all over again by looking into this particular position, and the ministry, in compliance with that order of the earlier case, has appointed the private respondent, Dr. Priyosiki, as director on additional charge basis till the regular directive is met. Whichever is earlier.
After the order of the court, they
Yes,
again
after the-
reconsidered, again put the private respondent in the charge of the
Yes,
director.
yes. So by that time, the ministry somehow found that here her name was at the top on the available list also. So then she was appointed. Then the present respondent, the main respondent, principal respondent has made a petition before the High Court, and it was not allowed to. It was not accepted. Then dismissed. Then they made an appeal. In the meantime, the period for which the lady doctor was appointed as director and additional charge got extended for a period up to 15/10/2022 also, October. So during this process, the process which was already on for appointment of regular director in such posts were had to be appointed by the initially had to be proposed from the ministry side, and had to be then ultimately by the appointment committee of cabinet. The process is on at the Prime Minister's office only. There are so many processes there in appointing a director also. So once the director is appointed also, on 1st of May, the regular director, but he was given a period of 1 month's time, 30 days time to join as a director, because there were some processes had to be followed before he is leaving the parent cadre also. So while doing the process also, he could not, the ministry could not complete the procedure of relieving this particular director who has been regularly appointed, Dr. Sunil Kumar, and the extension was to be met for his joining in the director's post. So during that period also, this particular case was sought to be heard on Saturday by video conferencing. It was on 3rd of June. Then when I submitted before the single bench that the new incumbent who has been appointed on regular basis was to join on the next working day, that is on 5th. Then matter was sought to be heard at length, and the judgment was delivered then and there also. But we could not find the copy of the judgment till beyond 11 a.m. in the Monday also. Then in the meantime, the ministry has directed the new incumbent to join, and he has accordingly joined on 4th. So after that, lawsuit, the present incumbent made a contempt petition also before the court, and by that time we had already preferred the SLP directly to the Supreme Court as the judges available. We have only 3 judges in Manipur. That is the difficulty lawsuit. That's why we are here. Then we made an SLP directly to the Supreme Court, saying that as there is no bench available, so the matter may kindly be taken up by the Supreme Court itself. Then it was somehow denied by the Supreme Court, but by staying the operation of the single bench judgment, it was we got a stay of 2 weeks time. So within that period, the Supreme Court directed us to file the appeal before the High Court. That we did lawsuit within the time. Then after that, the contempt was pursued so vigorously before the single bench lawsuit. And we had to again move a transfer petition before the Supreme Court, again back to the Supreme Court again. Then the Supreme Court was pleased to give us a stay of the contempt proceedings lawsuit. The contempt proceedings was stayed. And in the meantime, my friend had gone for another application, an IA, for early listing of the matter lawsuit. It was then postponed to some other later date lawsuit. Then it was somehow not acceded to by the Honorable Supreme Court, and it was declined. Then ultimately it got to be disposed of by 31st of lawsuit. That way, I mean, the matter has come to the High Court lawsuit. In the meantime, lawsuit, the present incumbent, Mr. Ranjit, Dr. Ranjit, who was by then had to be retired by 31st of August, has retired. The incumbents are already retired also.
So according to you,
Yes.
the person who was selected as a director
Yes,
was at that time was extended for him to join the post.
yes,
And who ultimately joined on 4th of June has retired.
yes.
Retired on 31st of
He
August.
retired on 31st. So there is nothing left to be decided in this matter as he has already retired.
So that post is since 31st of August, that post is lying vacant. So from.
No.
1st of
That is in the post of professors only.
Okay.
There is no
What
professor.
about
Director post is already filled up by joining the post by the new incumbent. That is why Dr. Sunil Kumar.
that the application that was filed before the Lanet single judge
Yes.
at that point of time, before the
Yes.
involvements, was relating to what?
Relating to additional charge. Relating to additional charge only.
Because that lady doctor who was already given as an additional.
No, he has already
substitute
left.
director.
He has already left. He has already demitted the office only because the regular director has already joined in.
Now, why that application was filed,
Which application was?
against which you went for an SLP?
No, SLP was against this particular judgment, which is being impugned in the present appeal.
No. Why that application was filed before the Lanet single judge for certain directions? Right.
No, there was filed by them only.
No, no, why? There has to be some certain press. You were
There is, they only say like, he should be allowed to continue till this present appeal is considered beyond the period of retirement.
as professor or as what? As additional director or as?
As professor, so that he could enjoy the fruit of that particular judgment who was favoring him. That was only payment before the single bench, the new case. So somehow the single bench has put off the matter and just adjourned it to, I think, 30th of October. The present matter, the writ petition which is pending before the single bench, which is
Now
lying
you
there.
are agreeing against the order of the Lanet single judge.
Single judge, early order.
Yes, what do you have to submit? According to the council for the appeal, it has become infructuous
Yes.
because.
My lord, writ petition is pending in the High Court, my lord, at present, because I don't want to enter into the merit in this division bench because it is appellate division bench. So, my lord, this is a very clear case where the this administration of justice was somehow one another delayed, and even the
We are not
Yeah,
on
that-
merit, we are not on merit at this stage. What we
My,
want
my
to
lord,
know-
if it is not only merit, my lord, what I am saying is that I represent only the respondent number one. I don't know about the two. So this matter, what I honestly pray is that this matter may be fixed. I won't seek any other adjournment, and this matter may be fixed on a date, and it may be disposed of by fully hearing, because in this honorable division bench, whether the order passed by the single judge was bad in the eye of law or it is correct, that decision I want.
But what council for the appeal submitted that at this stage,
Yes,
since the person concerned has retired on 31st of August,
yes.
it has become infructuous. Is it correct?
That part is correct, absolutely correct. I agree, man. I totally agree. But another writ petition is pending there because the fruit,
Now,
which,
the writ petition that is pending before the equal bench.
yes, my lord, awaiting, particularly we are awaiting this matter to be listed on 31st now.
Now, whether since this petition, according to the council for the appellant, has been infructuous.
My
that
lord,
petition has to be
my
heard.
lord, I think, my lord, yes, there is another case which also pending. It is not infructuous, but in another way, if it is either dismissed, stating that the order passed by the learned single judge, which has been challenged here, is bad in the eye of law, then it is another thing. But if it is infructuous, let the matter be withdrawn. The writ appeal be withdrawn. Not, it's not press.
Just tell us if it is infructuous, do you want to
Well, let
continue
him
to
withdraw
press?
by entering into the merit.
Yes.
I'll try my luck in the single bench. If it is.
Single bench, single
if
bench is
merit
waiting
is-
only for the outcome of this
Oh,
appeal. also.
whatever it is. So I am saying that it may be fixed for another day and for final.
Can be closed as infructuous law. So there is nothing remains to be
Then
decided.
it
also.
may be closed as infructuous without entering into the merit.
Yes, sir.
Yes, without entering into the merit.
Where is the repetition?
Petition is in the body of the appeal.
Also, I agree. If it is going to be disposed as infructuous without going into the merit, no problem, my lord. My statement also may be recorded.
91 laws, page 91. And the payer may kindly listen also. Payer portion is the clause, so page number 4.
104.
104 and 105. 105 is the relevant. Roman number 3 is very interesting. also. Pending appointment of regular directors. Once regular director is done, then there nothing remains left. Then single bench has somehow entered into that arena and put the entire appointment and the extension orders in abeyance. The appointment of the regular director was also not challenged also in the repetition, but somehow it has been touched upon.
My lord, I may be excused for intelligence, my lord.
Sure.
Just I want to highlight one point. This order, the single bench order which was challenged, was passed on 3/6/2023. During the operation of this order, while passing this order, both the councils are also present. Now, on 3rd it was passed, then again on next Sunday, the petitioner was, the doctor, which is supposed to work as a director, he was allowed to join on 4th or 5th June, I think 4th or on 4th, that is on Sunday. And there is one director also at that time, one insert director also. It doesn't mean that there is no director. Intentionally to frustrate the order passed by the Honorable Lanet Single Judge on 3/6/2023, they have allowed to join on Sunday. Medical service is emergency, I do agree. But joining of the director when there is another director who is the respondent number 2 here, when she was working as a director, how it has been challenged? It is
See, whether the respondent number 2 challenged the joining of the concerned director,
No,
regularly appointed director.
so far no.
What remains?
no, nowhere.
See,
I file contempt for me. I
You
file
are-
contempt.
you appeared for the petitioner.
Yes,
Respondent number
yes.
1. You
With
appeared for the
petitioner, my
petitioner.
lord,
in the-
actually another counsel
Counsel.
was there. I was not there. I came in the
In between.
Last stage. I came in the last stage.
Now, now Dr. L. Ranjit Singh Huppa filed the writ petition, right?
Yes,
Now he was agree with the order of page 157.
Piyosaki's appointment order. Yes,
So where it was clearly mentioned
yes,
that the appointment of Dr. Piyosaki was up to 11th of April 2023 or till regular appointment
Yes.
of a director of the Regional Institute of Medical Science Imphal or till further orders,
yes.
whichever is the earliest.
Yes,
So in between, while this order was passed, you challenged this order.
Yes, in the writ petition, it was challenged and it is set aside or quashed by the single judge.
When?
On the third June, my lord, at page 54 of the writ appeal, page 54 of
So
the,
the petitioner was aggrieved by the decision of the government
yes,
allowing
yes,
Dr. Piyosaki to
Yes, yes.
continue as the
yes,
additional director
Yes,
or
ma'am.
director in charge.
yes, absolutely correct. Yes, 54, Your Worship. Yes,
But in the meanwhile, a regular director has been considered and appointed and joined his service.
no, after passing the judgment,
True,
yes,
but the director in charge comes when? Only in the absence of the regular director.
correct. It is correct, absolutely correct. But kindly see, peruse the, my lord, direction number 6. Direction number 6, page 55. Direction number C. Your Worship, I may be allowed, I won't submit much, I may be allowed to draw your kind attention at the, from direction, last direction, that is 38, from 54, I may be allowed to read out. 54, page 54. Page 54. That judgment matter. In the writ petition is allowed and the order dated 16/1/2023, that is appointment of the respondent number 2 and the subsequent extension dated 10/4/2023 issued by the second respondents are set aside. Then B, it is disposed of. Then C, the respondent number 1, 2, 4 are directed to give additional charge of Director RIMS Imphal to the petitioner till his retirement in the month of September 2023. This direction was passed on the 3rd. Then, since the order dated 1/5/2023 has been issued without leave of court, and Dr. Guru Aripam Sunil Kumar Sharma, that is the regular director, has not joined duty, this court directs the respondent number 1 to 4 not to give effect of the order dated 1/5/2023 issued by the Deputy Secretary to the Government of India, Ministry of Health and Family Welfare Notice section, and the same shall be kept in abeyance.
Now, just
This is the violation of the court's order,
but,
direct court's order.
but in WPC number 65, was this order under challenge?
not at all. It came later.
His order,
This order of 1st of May 2023
yes.
was under challenge?
No,
Order
because
petition
because
amendment?
it came later on. It came
Then
later
how-
on.
just
It came
tell
during
us,
the pendency of the writ petition. It
with your
came on.
ex- with your experience in the bar, the order which was not under challenge,
Yes,
whether the Ranjit Singhal just could have interfered to it.
but whatever it is, my lord, I am not the
Just
one.
tell us.
It has been passed. The order has been passed,
True.
and now.
Probably that is the reason why this writ appeal. Probably.
Yes, yeah,
Before
correct,
the
correct.
SLP law.
Yeah, it is correct. I do agree. I do agree. But whether it is Lana
this
single judge
particular-
order, until unless it is stayed or set aside by a division bench, the sanctity of the judgment has to be maintained, my lord. It has to be maintained. How the order was passed on 3rd June.
Now, can you show us anything by which this particular order of the Deputy Director,
Yes.
Government of India, the Ministry of Health and Service, was a part of the pleading?
No, it was.
Nowhere.
No,
Nowhere.
because
also.
it was passed.
They have filed an application, an interlocutory application, only saying that by ignoring these orders, there has been issued on 1st of May, the petition be disposed of. They filed a miscellaneous application, wherein I filed an objection. They were saying that it is in conflict with their main prayer lawsuit, prayer number 3. It only says that prayer number 3, main prayer number 3, it only says that he may be allowed to hold a charge till the regular director comes.
See,
also.
Today is 27th of September.
Yes.
The petitioner, he will retire on 30th of September.
Yes.
Because what we have seen that in this order at page 55,
In the month of
No,
September.
that is wrongly reported, Lordship.
his retirement in the month of September
Yes.
2020.
He was to retire on 31st of August. Somehow it has been wrongly recorded as September 2023. Lordship.
The director concerned or
No, this is the present respondent, main respondent.
he has already retired.
No, he is already, that's what I submitted, Lordship.
So it petitioner has retired
Yes, real petition has retired.
at the age of 65 years.
Yes,
Superannuation.
yes.
Just. Any seniority list is here? Anything?
Yes, seniority list, but in the meantime, we have finalized the seniority list.
No, because we'll see the date of his date of birth from that.
Yes, there was an issue also. Yeah, and the present incumbent, the present respondent, lead petitioner,
L. Ranjit Singh.
during his time, he constituted a committee and sought to seek to finalize only for 5 professors. That was not acceded to by the ministry. Somehow, doesn't decline. And London Single Judge has passed the order on the basis of that seniority only. By that time, we have already issued the tentative seniority list and we have called for the objection by then also. And objections were called for, then objections were given also. And by this time also, it hasn't finalized.
Where is the final?
And,
No final seniority.
No, no, we have annexed it in the additional affidavit. Also.
Where is the-
Wasn't finalized and the WPSC is found to be the same also. Additional affidavit also, there was filed on, e-filing was done on 26th of this month also. And the physical filing was done yesterday. And our list is available at page number 325 also. Additional affidavit. When Joseph Devi is found to be senior also. If he agreed, then he could have gone for another round of litigation. By the time he's already retired, so there's no point also. There's number 325, 326, it is available also. Additional affidavit.
This seniority list was published after the passing of the single bench order.
Yes, yes, yes. In the meantime, we have finalized.
But it has nothing to do with this, with the petition. It was, this was published on 30th. And the order was passed on 3rd June. Even in the final seniority list, the date of birth of the petitioner is also still wrong. Date of birth, which has been reflected in the single bench order.
आपको
What's your good name, sir?
Samarjit, K. Samarjit. I'm the deputy solicitor.
Bro.
Give
We'll just give it a right.
Wait,
Yes.
What, Mr. Satyam?
K. Samarjit.
Deputy Solicitor General of India. Assisted by MS. Devi. Also heard. Justice such and such. You are appearing for one?
I'm appearing for the only one.
Okay. Respondent number 1/3 petition. Matter pertains to appointment of director. The in additional charge, director in charge of a regional institute of medical science. Import. Pursuant to the order issued by the order number 12025/15 of 2020. As any. Yes, but please take your seat. Please take your seat.
Yes, Lord.
But please take your seat.
Yes, yes.
Part within bracket, numerical one. Ministry of Health and Family Affairs. Yeah. Dated 16/01/2023. Whereby Dr. H. P.O. Sakhi Devi was entrusted to be the director in charge of the RIMS Import. P.O. Sakhi Devi, Professor ENT RIMS Import. As director in charge of RIMS Import up to 11/04/2023. Or the regular appointment of director of RIMS Import or till further orders, whichever is the earliest. By the said order dated 16/01/2023, the Government of India in its Ministry of Health and Family Welfare cancelled the appointment of the respondent number 1/writ petitioner, Dr. L. Ranjit Singh, Professor of Obstetrics and Gynecology, RIMS Import, as the director in charge of RIMS Import in compliance of the order of the dated 19/12/2022 in WPC number 867/2020. In WPC number 65/2023, filed before the Honorable Manipur High Court in court. The response number 1, Dr. L. Ranjit Singh, Professor of State and Guidance, IIMC. Amongst others, grade 4, page 104, 105. In say WPC number such and such, the Honorable Single Judge on 03/06/2023 passed an order with the following directions and observations. My apologies, Department of Education. Against the same, because of the non-compliance of the said order, the writ petitioner and the person also preferred a contempt petition. The present appellant preferred special leave to appeal before the Honorable Apex Court against this judgment and order from the date 03/06/2023, passed in WPC number 65, wherein the Honorable Apex Court by its order the date 29/08/2023 observed as follows. Case number 2, harmonized asset. In that background, this appeal placed before this court. During the deliberation of the matter, Mr. Such and such, learned Deputy SGI apprised the court that the regular director of RIMS Import, pursuant to the appointment order issued by the Ministry of Health and Sciences, Government of India, joined his service on 4th of April, no, June, 4th of June, 2023, and is serving in that post. It is also placed before the court by the appellant, Mr. Sassan counsel for the appellant, that the writ petitioner, L. Ranjit Singh, has already retired from service on 31/08/2023 on attaining the age of superannuation at the age of 65 years. From the seniority list, of 5 professors of RIMS determined by a committee constituting of 4 consent committee of 4 persons constituted by the writ petition on 17/12/2022 in its meeting held on 09/01/2023 determined the petitioner Dr. L. Ranjit Singh as the senior most professor of RIMS Imphal, in which the date of birth of the writ petitioner respondent number 1 here it reflected as 1st of September 1958. Considering therefore the petitioner had already attained the age of 65 years on 31st of August 2023. Placing the above, London Senior Counsel such and such, Deputy SGI, appearing for the appellate, submitted that at this stage, as the writ petitioner has already retired from service on 31/08/2023. This said, the appeal as well as the writ petition has become infructuous, to which the learned counsel for the respondent number 1/writ petitioner, Mr. Submitted admitted the fact that the writ petitioner has already retired from service on 31 days of superannuation at 65 years. Considering the above, as per for district appeal being infructuous, stands disposed of.
I beg your pardon, Lordship. Regarding the seniority list of 5 professors, that has not been accepted by the ministry. Subsequently, we have finalized it and we have enclosed it in the additional affidavit also.
Whatever it is, my lord.
The
Seniority
factual-
and all, it all published after 30, on 30th June.
But the factual part should go, I mean,
That is not an issue here.
yes, it's not an issue here.
Where is the additional affidavit?
Additional affidavit,
Give us page number.
Page number 325 also. That has been finalized by letter dated 36/23 also, wherein Joseph Devi was found to be the same also.
325.
Yes, also. X26.
X26.
Yes.
It's not here.
No, additional affidavit was. No. Physically, it was filed yesterday and email filing was done on 26.
Do you have a copy?
Yes, was.
Ms. Devi, it was filed yesterday.
Yes, physical.
And also placed for the court. By which order you have approved?
325 PS, X26 lawsuit. There is letter dated 36/23.
Oh.
Yes, sir.
There's also place such and such. Also apprised you that the state government, the government of India in its Ministry of Health and Family Welfare, within bracket notice section, by order under number F dot number U dash 12025/01/2023 dash NE 30/06/2023 approved the interdisciplinary list of professors of RIMS Imphal finalized in the meeting held on 17/06/2023.
Yes, yes.
Read in very little. And this is meeting. The date of birth of the writ petitioner, Dr. Ranjit Singh, reflected as 01/09.
My lord, I humble the submission, my lord. One admitted fact also may be recorded that the regular director has joined on 4th.
That has already been put.
Yes, yes. There has been.
Similar issue earlier cropped up in the joining and with regard to the aims. That's I think so. It is a reported judgment. Person concerned who joined is the head of the aims was on a holiday.
Yes.
And it was challenged by an
No,
SMS doctor.
it is not about the
RIMS
holiday. It
is
is
open
after
24
passing of
hours.
the judgment.
Oh, they will apply, sir.
Yes, what is this I for?
I have, after filing the petition, my lord, petitioner has been arrested and kept in detention camp, my lord. So I filed for releasing him from detention camp, my lord.
When he was taken into custody,
On 7/6/23, my lord.
where you have mentioned.
Yes. There are 3, my lord, of I, my lord. Case 6.
Has to be bordered around.
My lord.
Mr. Sharma, Mr. Ali, 5,000 and the normal process of order reports.
In the main case, we are directed to produce the total list also of price on this.
This is the importation the one next time when we will take up that
Yes.
matter for admission. Transport of- Mr. HR Ahmed, counsel for the petition, applicant slash the petitioner. And Mr. LDB government. And it says this for the opposite party number 1 as well as standing counsel. Opposite party number 6. Mr. Sharma, B. Sharma, standing counsel. Sorry, Ali. Standing counsel election commission, opposite party number 2. I think Mr. Ali will also be for opposite party number 7. Is 3.
Yes.
Sharma for 3 and 4. and Mr. P. Sharma, Government Advocate Assam, for the response number 5.
Obligation.
Main expedition. I will keep it close and accuracy. Mr. Ali? Yes. In the connected read petition, which you have just,
Yes, sir.
Mr. David, just on the next date indicate whether those name of those persons who directly indicates in the voter list.
As for my institution, this already there, Your Lordship.
Just
I'll
leave
back in.
and indicate the number and all. So
Yes, sir.
Mr. Sharma will pass the ticket.
Yes.
Correct. The petition. The prayer of the council for the petition, take this matter for admission in the week commencing from 16 to,
So fix a date on that.
we're not fixing, commencing from 16th. Let the registration. Yes, Madam Sharma. What we have seen here, the case of the applicant before the tribunal was that in 2013, the CBI wrote a letter to the heads of the CBA
Lordship.
and only on
17 weeks.
17/3,
Charge memorandum was issued.
right. So there is a delay of 4 years.
Yes, Lordship.
Was the learned tribunal accepted
Yes.
and considering the same allowed the
Original
application
application.
preferred by the.
Yes.
Now, in your reply, your written statement before the tribunal, only ground that you have placed is there is a delay on the part of the applicant to file his reply by 6 months. Now, just show us anything that the delay of initiating the disciplinary proceeding, the grounds of the delay, grounds for such delay in preferring or initiating the disciplinary proceeding against the applicant. Have you ever said anything in that regard in your written statement before the tribunal?
Lordship, my written statement already. Page 192, Lordship, that,
We have read a part of that on that day.
yes, Lordship.
We have not
Uh,
completely read.
Yes, page 192. It is pertinent to mention here that a careful perusal of the representation would show that the applicant was reluctant to go on departmental proceeding pending criminal trial, and that he took more than 6 months to send a statement of defense against the charge sheet. Applicant was reluctant to go on with the departmental inquiry pending criminal trial in respect of the same incident is clearly a stop from contending before this honorable tribunal that the charge sheet is in respect of an incident of 2012 and that the charge sheet is continuing to pen for a very long period and hence should be quashed on the ground of delay. Allegation of delay by the applicant therefore cannot be an allegation which can lie in his mouth. It is further respectfully submitted that the Honorable Supreme Court repeatedly considered in a Katana ruling that whenever the integrity is in doubt, a departmental proceeding should not be normally quashed on the ground of delay as long as the applicant is not able to show that the delay has caused any prejudice to him. In the present case, since the criminal case was already lodged in 2014, it cannot be contended by the applicant that the pendency of the charge sheet which was issued to him as late as on 21/4/2017 and in respect whereof he did not give his statement of defense for a period of more than 6 months should be quashed by this honorable tribunal on the ground of gross delay. In this regard, the respondents are seeking to refer to and rely upon the judgments. Judgments we have already discussed on that date, Lordship. So those are the main contention, Lordship.
So as such, there is no such ground on your part, right?
Lordship.
Show the delay of 4 years.
So again, Lordship, in page 194
Your
also.
only ground is that because of the Honorable Apex Court, in some of the cases have held that on the ground of delay, such charges should not be dealt,
Yes, yes,
set aside.
yes,
But you fail to explain the delay.
Lordship. So again, our another contention is page 194 that the applicant has not intimated, Lordship. Page 194, the last paragraph. Never further communication has been received from CBI, ACB, nor has the applicant intimated to respondent department anything in this regard. Applicant has not brought full fact to the honorable tribunal. Further, applicant cannot claim negative equity. As per charges filed in CBI Court, Mumbai, so and so, copy of which was received by the respondent number 3 on 27/11/2014. Para 3 and 4, Sri Milind Binayak Golekar was director of so and so, was acting as an agent of different companies which supplies goods to CST, and there was an agreement with the CST listed companies and Messrs. Sankalpa Consumer Products Private. It is further alleged that Sri Milind Binayak Golekar, having official dealing with so and so Mumbai pertaining to supply of product by the companies to CST for logistic support, and in return so and so has helped Milind Binayak Golekar by giving him advices, consultancy in sorting out the queries of CST related matters. This release of payment against supply in favor of Messrs. Sankalpa Consumer Products Private Limited. It is alleged in para 8 so and so that Sri Milind Binayak Golekar was director of Messrs. Sankalpa Consumer Products Private Limited. In order to run his business with CST, has evaded Sri KK Srivastava AGM CST by giving bribe in kind, that is by providing the convenience facilities by hiring vehicle from different travel agencies and railway tickets to Sri KK Srivastava and his family members as per recruitment from so Sri KK Srivastava, thereby has committed crime under section 12 of PCR 1988. This is in the CBI court, Lordship. It is submitted that the applicant is claiming negative equity. There is clear distinction in case of applicant. So these are on other points, Lordship, not on the point of delay, Lordship. To be frank, Lordship, that CBI case, he was acquitted, Lordship, subsequently.
Where is that order?
That order,
Okay.
they have,
We'll hear it from Dr. India.
yes, Lordship.
Anything else?
So these are my humble ground, Lordship. And third one is that we have taken a ground here, Lordship, that our case laws were not at all discussed by the Honorable Tribunal. And we have also given one that we will complete the investigation within 6 months. That is also our another ground, Lordship, in this writ petition. And my page 23, I have taken that ground also, Lordship. So basically, these are the main facts, Lordship. And he
And
is,
you rely on which judgment?
yes, Lordship, that we have already annexed here, Lordship. Muhammad Ibrahim, then P. Padmanabhan, and Sachindranath Pandey. These are the judgments, Lordship. Anantar Kulkarni. The 4 judgments from page 307 onwards to 334. And the one thing is that, Lordship, till that, Lordship, the respondent is not prejudiced. We have only fixed for hearing, Lordship. No, departmental proceeding had not finalized any order or any such types of sentence against him, Lordship. We have fixed only the date of preliminary hearing, Lordship. Till date, no prejudice has called for the appellant, respondent, Lordship. It's only fixed a matter for preliminary hearing. And if the person is acquitted by that CBI court also, Lordship, he can very well place that before the departmental authority also, Lordship. So it's in a premature stage, Lordship.
Anything else?
So these are my
Show us from the judgment that you have cited before the honorable
Lordship.
tribunal was not discussed or not considered.
So here page 348,
The judgment starts as page 335, right?
yes. So paragraph, page 12, from paragraph 10, the submission of the learned central government standing council in before the honorable tribunal, Lordship.
Please take your seat.
Subo que es la reputación tanto, pues, de la que no empiezan a
Fantastic. Yes. There's a question.
Yes, Mr. Doctor.
Although your lordships have heard the facts already, but I'll just place certain dates. The allegation is that there was an exchange of rupees of 1,98,829 between the respondent and one director of Messrs. Sunfall Consumer Products. The period in question when this transaction was allegedly taking place is November 2008 to June 2012. November 2008 to June 2012. And your lordship will find mention of this period at page 73, that is in the article of charge. Now, it has been alleged that during this period, there was official dealings between the respondent and the so-called director of Messrs. Sunfall Consumer Products, and thereby the respondent had taken the services of that particular company towards hiring charges of vehicles and railway tickets. As against this, my lord, this incident, the CBI filed a charge sheet in the year 2014, but the FIR came much before that. Your lordship will find the FIR at page 209. At page 209, the FIR number is quoted, that is of 3rd of December 2012. So for the incident that took place between November 2008 to June 2012, the FIR was registered in the month of December 2012. And thereafter, the charge sheet in the present case was issued on 21st of April 2017. Therefore, from the time of alleged commission of misconduct till the time of initiation of the disciplinary proceeding, there is a delay of about 9 years, if it is calculated from the year 2008. If it is calculated from the year 2012, in that case also, the delay is of 5 years. And there is absolutely no explanation whatsoever as to the cause of this delay. One submission has come from the side of the petitioners that the respondent had delayed the filing of written statement by 6 months, and therefore the delay has caused. In my respectful submission, my lord, this is entirely misplaced. The reason being that a disciplinary proceeding commences on the issuance of the charge sheet, not on the filing of the written statement. So even if it is assumed that the disciplinary in the written statement that the respondent had filed, there was a time taken for 6 months, that will not save the purpose of that will not offer an explanation to the petitioners. But it has been held so in the case of KV Janakiraman, and also it was clarified later in the case of Delhi Development Authority versus HC Khurana. I'll just place the citation to your lordships. Your lordship can kindly peruse paragraph 9. That is very much clear that the disciplinary proceeding starts on the issuance of the charge sheet, and it is not thereafter. If your lordship will kindly come to paragraph 9. The question is now, what is the stage when it can be said that a decision has been taken to initiate disciplinary proceedings? We have no doubt that the decision to initiate disciplinary proceedings cannot be subsequent to the issuance of the charge sheet. Since issue of the charge sheet is a consequence of the decision to initiate disciplinary proceedings, framing of the charge sheet is the first step taken for holding the inquiry into the allegations on the decision taken to initiate disciplinary proceedings. The charge sheet is framed on the basis of the allegations made against the government servant. The charge sheet is then served on him to enable him to give his explanation. If the explanation is satisfactory, the proceedings are closed. Otherwise, an inquiry is held into the charges. If the charges are not proved, the proceedings are closed and the government servant exonerated. But if the charges are proved, the penalty follows. Thus, the service of charge sheet on the government servant follows the decision to initiate disciplinary proceeding, and it does not precede or coincide with that decision. The delay, if any, in the service of the charge sheet to the government servant after it has been framed and dispatched does not have the effect of delaying initiation of the disciplinary proceeding, inasmuch as information to the government servant of the charges framed against him by the service of the charge sheet is not a part of the decision-making process of the authorities for initiating disciplinary proceeding. So therefore, it cannot be argued that merely because there was a delay of 6 months on my part to submit the written statement, so it would be construed that the proceedings would commence after submission of my written statement. So evidently, my lord, from the facts of the case, the alleged from the time of alleged misconduct and the time when the charge sheet was served, there is a delay of about 9 years. And if the last leg of the happening is taken into account, still that would constitute a delay of about 5 years in commencement of disciplinary proceeding. And for this entire period, there is absolutely no material. So this is as far as the first part of the case is concerned. Now, your lordship yesterday asked my learned friend that which are the companies, because in the charge sheet you have said that there were certain companies with the registered with the CSD for whom the benefit was exchanged. Now, your lordship's query to my learned friend was, where are the names of those companies? The charge sheet does not mention any of the names. If your lordship at the cost of repetition will again come back to page 71, your lordship will find, more particularly in page 74, it does not disclose that which are the companies with whom the Sankalp agency had allegedly dealings or it was agents. Now, my learned friend had referred to page number 222 yesterday to demonstrate the names of the companies. Sorry, page 213 yesterday to demonstrate the names of the companies. Now, if your lordship will kindly come to 213, your lordship will find that this is not the charge sheet in the disciplinary proceeding. This is the charge sheet in the criminal case. 213 is part of the charge sheet in the criminal case, which has already been quashed now. So by banking upon the charge sheet, which is not in existence now, you cannot sought to supplement your case that these are the companies against whom we alleged that there was misconduct. So there, on this count also, my lord, there is nothing in the charge sheet which constitutes a misconduct as against me. And if your lordship will kindly consider one aspect of the matter, what post I was holding. I was holding a class 1 gazetted post in the respondent department, sorry, the petitioner, under the petitioners. The allegation is that over a period of 3 years and 7 months, there was a bill which I had to foot amounting to 198,829. I just did a rough calculation, my lord, it comes to an expense of around 5,000 rupees a month. Is it very unreasonable, unrealistic on the part of a class 1 gazetted officer to spend this much of money on account of transportation charges? This is the sum and substance of their charge, that over a period of 3 years and 7 months, a bill of 198,829 had to be put, and there is no corresponding loss to the government. These bills were not also asked for being reimbursed.
Yes.
Now, naturally, my lord, a query came to my mind that if it was not to be done so, then why there was a disciplinary proceeding? Why, after all, after so many years, a proceeding was taken up against the respondent? The fact is like this, my lord. In the year 1st of January 2003, he was promoted as Assistant General Manager. And thereafter, in the year 2008, he became entitled to be promoted to the post of Deputy General Manager. That became the bone of contention between his rivals, and this disciplinary proceeding was initiated. Initially, he was suspended. That suspension order was challenged before CAT Chandigarh bench. Your Lordship, I'll take your Lordship to that order of the Chandigarh bench. Your Lordship will kindly see that. And the suspension order was quashed. But to prevent him from getting the benefit of further promotions and all, this entire thing was cooked up. Your Lordship will kindly come to the order of the tribunal, that is at page 186. And there is categorical finding by the tribunal, the admitted position that there was no dealing of this kind. He had not taken any money to the detriment of the government. Your Lordship will kindly come to paragraph 22 at page 186. At page 186, paragraph 22. It was in the context of the suspension order which was challenged. Now dealing with the last question of discrimination vis-a-vis the other employees, it is admitted by the respondents. Your Lordship will kindly mark these words. It is admitted by the respondents that it is not the applicant who has got any benefit from the supplier firm, whereas there are other officers of the respondent department who also got similar benefits, which is not denied by the respondents in their written statement. They have rather reimbursed those bills, and to them only show cause notices have been issued. The other set of employees, my lord, they also hired the vehicles, availed the services, and also got the expenses reimbursed by the department. But still nothing was taken up against them. There is no denial by the respondents in the written statement to the averment made by the applicant that he has not even got reimbursement of any bill by causing financial loss to the government. And this order has attained finality. There is no challenge to these findings. Though as per the settled law, the negative equality cannot be claimed, but to have the complete justice, we have to ensure that the action of the respondents is not arbitrary or discriminatory. Now, thereafter, going into the other aspects of the matter, my lord, the suspension order was set aside, and he was asked to be reinstated in service. Despite that, my lord, after this was passed, this was 2000. The OA was filed in the year 2014. Your Lordship will kindly notice the date of the judgment. The date of the judgment, your Lordship will find at page 166. Has your Lordship got it? 166 top. Date of decision is 25/11/2014. So it cannot be said that they were not aware of the facts, that they were unaware of happenings in the department. They fully contested this application, and not only this, there were several other original applications filed before the tribunal regarding the claim of promotion and the consequence of non-payment of benefits during the period of suspension. So it cannot, the respondents cannot say, the petitioners before your Lordship now, that they were unaware of the things and they came to know about it only after the CBI filed charge sheet. So this was all happening in the year 2014. Still, they did not initiate the disciplinary proceeding. The reason is very simple, that the moment his entitlement became due in pursuance of the judgment of the learned tribunal, now thereafter the charge sheet comes in the year 2017. And your Lordship knows that if a charge sheet is pending against some some person, his case will go into seal cover procedure. The man had to retire at the post of AGM without getting the promotion. His promotion cases are pending now. Thereafter, your lordship will kindly see another aspect of the matter. This is as far as the delay and the motive behind this entire game. The only motive is to frustrate his promotion, nothing else. He is a decorated officer, my lord. I have enclosed the certificates and accolades that have been given to him during his entire service career. There is nothing adverse so far, and the tribunal has also taken note of it, that in the entire of his service career there is no blemish. The second aspect of the matter, my lord, that has gone with the that has weighed with the tribunal is the identity of the charges. If your lordship will kindly see the charge sheet in the CBI case and the charge sheet in the departmental proceeding, the list of documents which have been enclosed there, in verbatim, my lord, these are same. And this has to be, because they are all along their case has been that the charge sheet, departmental charge sheet had to be issued only after the CBI had nudged them. So their case cannot be on a better footing other than the case put up or framed by the CBI. The CBI charge sheet, your lordship will find at page 222. The list of documents are mentioned there. And just on contrast, if your lordship holds the page 76, that is the list of documents in the departmental proceeding. The first document in the departmental proceeding is the FIR in the CBI case, and all other documents, total 17 in number. These are in verbatim the exact documents, my lord, that are listed in page 222. In the additional affidavit that I have filed before your lordship, my lord, I have highlighted that what are the identity of these documents and how they are similar. They are the exact evidence in both the cases. Now, as has been suggested, as has been stated by my learned friend, that this CBI charge sheet has been quashed. In the additional affidavit that I have filed, the charge sheet, the decision of the Honorable Bombay High Court has been placed before your lordship. The actually discharge petition was filed before the special court. The discharge petition was not allowed, and therefore a quashing petition was filed before the High Court. The Honorable High Court has quashed the proceeding, and the entire proceeding has gone now. So that is the present status. Now, the question of prejudice, your lordship will kindly see the learned tribunal at page 335. The tribunal has gone with the case of M. Paul Anthony, and the particular paragraph 33 is quoted at page 369. What is the effect where the charges are identical and the entire set of evidence is also same? Paragraph 40 at page 369, your lordship will kindly read. In Captain M. Paul Anthony versus Bharat Gold Mines Limited, the Honorable Supreme Court held as hereunder. There is yet another reason for discarding the whole of the case of the respondents. As pointed out earlier, the criminal case as also the departmental proceedings were based on identical set of facts, namely the raid conducted at the appellant's residence and recovery of incriminating articles therefrom. The findings recorded by the inquiry officer, a copy of which has been placed before us, indicate that the charges framed against the appellant were sought to be proved by the police officers and punch witnesses who had raided the house of the appellant and had effected recovery. They were the only witnesses examined by the inquiry officer, and the inquiry officer, relying upon their statement, came to the conclusion that the charges were examined in the criminal cases, but the court, on a consideration of the entire evidence, came to a conclusion that no search was conducted and nor was any recovery made from the residence of the appellant. The whole case of the prosecution was thrown out and the appellant was acquitted. In this situation, therefore, where the appellant is acquitted by a judicial pronouncement with the findings that the raid and recover at the residence of the appellant were not proved, it would be unfair and rather oppressive to allow the findings recorded at the ex parte departmental proceedings to stand. Here also is the case, my lord, the entire charge sheet, because the basis of this departmental proceeding is the charge sheet by the CBI. That is the very foundation of the departmental proceeding. And that charge sheet of the CBI has been quashed by a competent court of law. Therefore, in such circumstance, my lord, the tribunal was absolutely justified. Although, my lord, at the time when the tribunal was deciding the case, the judgment of the Honorable High Court was yet to come. But as the things stand out today, the reference to this particular case, M. Paul Anthony's case, is absolutely justified by the tribunal. Now, regarding the case laws that have been relied on by them, a submission has been made that the tribunal did not consider these case laws which were placed for consideration. Now, there are, from the reference, my lord, that have been made, I find that 4 cases were referred to by them. I'll just briefly take your lordship through these cases and try to convince your lordship that these are not at all applicable to the facts of the case, and therefore no prejudice has been caused to them if the tribunal had not recorded any discussion on these.
Yes. Mr. Jatta, you think?
Now, if your lordship will kindly come to page 307, my lord, I'll just briefly indicate that why these judgments are not at all applicable and therefore not discussing anything by the tribunal will not cause any, did not cause any prejudice to them. Your lordship will kindly come to page 307. That is the case between Union of India and Muhammad Ibrahim. Now, here was a case, my lord. It's only an order.
No.
Two
Tell us, we are not on to that extent.
lordship.
What is the submission of Mr. Sharma was that though these judgments were placed, the Honorable Tribunal did not discuss these issues. The judgments placed on behalf of the respondent union.
Yes.
So what we have noticed at paragraph 46, I think so, the judgment of the tribunal's order.
Page 46. Para 46. Para 46 is a judgment that was referred by us, my lord. That is also in the brief. And para 47, perhaps your lordship is showing. Para 47.
Para 45, 47.
Yes, these are the cases discussed by the, cited by the.
Cases cited by the Union of India.
Yes.
was considered.
Yes.
The other few cases have been placed, not considered, not.
Gilead cases were not considered, but the Sangram cases, case, etc., are on the basis that premature, without that delay part was not considered.
Now, on the aspect of delay, my lord, these four cases have been placed at page 307 to 328, my lord. These are the four cases that the petitioners are now pressing now. If your lordship will kindly come to page 307, my lord, this is not even a judgment. Nothing is discussed here. It does not also indicate what are the charges. So it cannot be relied upon as a precedent. Then next case is at page 308. Now in 308, your lordship will see this was a case where the first disciplinary proceeding was quashed by the High Court. There was a second disciplinary proceeding initiated on fresh issues, and the order of disciplinary authority was set aside on the ground that the inquiry officer did not have the power to issue charges. If your lordship will kindly come to page 309, on the top your lordship will find this. In the instant case, the inquiry officer had himself framed the charges. So this was the illegality in the inquiry proceeding, and therefore the High Court had set it aside. And thereafter the second charge was, the second proceeding was taken, and page 312 your lordship will find. Page 312, second paragraph. In that case, the disciplinary proceedings were initiated 5 years after the appellant therein had handed over charge. Now, in between, what has happened, my lord? When the first proceeding was quashed and the second was initiated, in between the person had retired, and the plea of delay was taken. The Honorable Apex Court had taken resort to the rules under the, the provisions under the pension rules, where it says that if on the date of superannuation some disciplinary proceeding is pending, then it will be deemed to have continued. And taking resort to that rule, my lord, the order of the Honorable High Court was set aside. So the facts of that particular case, the Padmanabhan case and the case before your lordships are entirely different. There is no similarity. It was on interpretation of the rules of the pension. Now, next case is at page 314. That is Anant Kulkarni. This case, rather, I'll humbly submit, my lord, this case rather supports the case of the respondent before your lordship. In Anant Kulkarni case, my lord, the first paragraph your lordship may notice, this appeal has been preferred against the impugned judgment and order dated so-and-so of the High Court of Judicature at Bombay in LPA number so-and-so arising out of so-and-so, by which the division bench of the High Court upheld the judgment of the learned single judge, as well that of the school's tribunal, quashing the inquiry against the appellant while giving liberty to the respondent number 1 and 2 to hold fresh inquiry on the charges leveled against the appellant. This is the subject. Now, this was challenged because the appellant said that if you have quashed the inquiry, then further liberty could not have been given to the respondent department to proceed afresh. And your lordship will kindly see the findings In this case, after elaborate discussion of all the case laws, my lord, ultimately, page 324, para 29. In the facts and circumstances of the case, as the tribunal, as well as the learned single judge have examined all the charges on merit and also found that the inquiry has not been conducted as per rules of 81. It was not the cause of the management committee which had been prejudiced. Rather, it had been the other way around. In such a fact situation, it was not necessary for the division bench to permit the respondents to hold a fresh inquiry on the said charges, and that too after more than a decade of the retirement of the appellant. In view of the above, the appeal succeeds and is allowed. So it no way supports their case, my lord. It rather will support the respondent's case before your lordship, that he is a retired person and it's a decade old. Now by lapse of time, it's more than a decade old issue. That should not be gone, that need not be gone into. More so when the charge sheet in the CBI case has been quashed.
Please come to 316.
316, yes.
Now read para 7.
Yes, it is a settled legal proposition that once the court sets aside an order of punishment on the ground that the inquiry was not properly conducted, the court should not severely preclude the employer from holding the inquiry in accordance with law. It must remit the concerned case to the disciplinary authority to conduct the inquiry from the point that it stood vitiated and to conclude the same in accordance with law. However, resorting to such a course depends upon the gravity of the delinquency involved. Thus, the court must examine the magnitude of the misconduct alleged against the delinquent employee. It is in this view that this court tribunals are not competent to quash charge sheet and related disciplinary proceedings before the same are concluded on the aforementioned ground. This is because, my lord, the Hyderabad ECIL Hyderabad's case was referred.
Now,
But-
read the next para, which relates to inquiry at belated stage.
Yes, the court tribunal should not generally set aside the departmental inquiry and quash the charges on the ground of delay in initiation of disciplinary proceedings, as such a power is dehors such a power the limitation of judicial review. In the event that the court tribunal exercises such power, it exceeds its power of judicial review at the very threshold. Therefore, a charge sheet or show cause notice issued in the course of disciplinary proceedings cannot ordinarily be quashed by court. The same principle is applicable in relation to there being a delay in conclusion of disciplinary proceedings. The facts and circumstances of the case in question must be carefully examined, taking into consideration the gravity and magnitude of charges involved therein. The court has to consider the seriousness and magnitude of the charges, and while doing so, the court must weigh all the facts, both for and against delinquent officers, and come to the conclusion which is just and proper, considering the circumstances involved. The essence of the matter is that the court must take into consideration all relevant facts and balance and weigh the same so as to determine if it is in fact in the interest of clean and honest administration that the said proceedings are allowed to be terminated only on the ground of a delay in their conclusion. Then the case law. My lord, this is nothing but a summation of the laws on the point. But the final conclusion, the Honorable Apex Court.
It was a case where the proceeding initiated against a person who already retired 10 years after the retirement.
Yes. So therefore, my lord, my first submission was that this case also does not apply to the facts of the present case. The facts of the present case are different entirely. Therefore, and despite discussing all the case laws on the point, my lord, the final decision of the Honorable Court, ultimately the ratio is in the final determination. Final determination is at page 324, where the Honorable Court had interfered with the quashing of the, did not interfere with the order of the High Court quashing
It is
the.
at para 21 at page 322.
The tribunal as well as the learned single judge of the High Court had recorded a categorical finding of fact to the effect that initiation of departmental inquiry against the appellant had been done with malafide intention to harass him. The charges were not specific and precise. In fact, they were vague and unspecific. Furthermore, the management committee had failed to observe the procedure prescribed in Rule 36, 37 of Rule so and so. The said rules prescribed a complete procedure for the purpose of holding an inquiry, wherein it is clearly stated that an inquiry committee should have minimum 3 members, 1 representative from the management committee, 1 to be nominated by the employees from amongst themselves, and 1 to be chosen by the chief executive officer from amongst a panel of teachers who have been awarded national state awards. In the instant case, there was only a 2-member committee. The procedure prescribed under rules is based on the principles of natural justice and fair play to ensure that an employee of a private school may not be condemned unheard. It is pertinent to note that the management committee failed to prove even a single charge against the appellant. Now, this was also gone into by the honorable courts, the tribunal and the single bench and division bench. Therefore, your lordship will find in para 29 that it was gone into in great detail that why the charges are not to be.
Read para 27, 28.
We may add that the court has not been apprised of any rule that may confer any statutory power on the management to hold a fresh inquiry after the retirement of an employee. In the absence of any such authority, the division bench has erred in creating a post-retirement forum that may not be permissible in law. In the light of the facts and circumstances of the case, none of the charges are specific and precise. The charges have not been accompanied by any statement of allegations or any details thereof. It is not therefore permissible for the respondents to hold an inquiry on such charges. Moreover, it is a settled legal proposition that a departmental inquiry can be quashed on the ground of delay, provided the charges are not very grave. And therefore, the ultimate finding in para 29. That's why I said, my lord, that this judgment does not help their case. The next case is in page 325. This was a case, my lord, where the respondent was non-cooperative from the very beginning. He did not participate in the inquiry. He also evaded service of charge sheet on him. And it was on that fact consideration that the final decision of the Supreme Court was rendered. Although the Allahabad High Court had interfered with the proceeding on the ground that since inquiry report was not served on him, so the proceedings will go. But ultimately, the Honorable Supreme Court said, the Supreme Court interfered with that order. Paragraph 7 at page 327, your lordship will kindly see. On a perusal of charges, we find that the charges are very serious. We are therefore not inclined to close the matter only on the ground that about 16 years have elapsed since the date of commencement of the disciplinary proceeding. More particularly, when the appellant alone cannot be held responsible for this, delay. So far as the merits are concerned, we regret to say that the High Court has not dealt with the submission of the appellant, that in spite of being given a number of opportunities, the first respondent has failed to avail of them. If the appellant's allegations are true, then the appellant cannot be faulted for not holding a regular inquiry, recording of evidence of witnesses and so on. The High Court has assumed, even without referring to Regulation 68, aforesaid, that holding of an oral inquiry was obligatory. Indeed, on one of the questions in the writ petition may be the interpretation of Regulation 68. On facts, the first respondent has his own version. In these circumstances, the writ petition could not have been allowed unless it was held that the appellant's version of events is not true and that the first respondent's version is true. In these circumstances, we have no alternative but to set aside the order under appeal and remit the matter to the High Court once again for disposal of the writ petition afresh in the light of the observations made herein. Since the matter is a very old one, it is but appropriate that the matter is dealt with expeditiously. Perhaps it would be appropriate if the court looks into the records relating to the disciplinary proceedings also. Here it was a case where the proceeding was not concluding for 16 years. So that the fact circumstance is also again different. In my case, I have come at the initiation of the proceeding, challenging the charge sheet, and there the challenge was that the proceeding was pending for 16 long years and it was not being concluded on this or that count. The next case is at page 328, and the first paragraph your lordship will see. Second paragraph, under the order impugned herein, the High Court of Punjab and Haryana has quashed the memo of charges communicated to the respondent writ petitioner as well as the order appointing the inquiry officer to inquire into the charges. A further direction has been given to the appellants, namely the state of Punjab and its authorities, to consider the case of the respondent for the purpose for promotion according to law. The correctness of the said order is questioned by the state of Punjab and authorities in this appeal. Here also, your lordship will find the facts are entirely different.
Paragraph 6.
Paragraph 6 and paragraph 7, your lordship will also, the charges are quoted there. The respondent was, it is the High Court quashed the memo of charges on the following grounds: the delay of 5.5 years in serving the memo of charges. The memo of charges was not served, for which there is no acceptable explanation. It is itself a ground for quashing the charge. On account of lapse of time, it has become difficult for the respondent to adduce evidence or to prove his innocence. Number of witnesses he could have examined are either dead or no longer available. Some of them have either retired or transferred elsewhere. The jail has also been repaired with the result of the evidence of is missing. Holding an inquiry at this distance of time cannot but prejudice the respondent. The subdivisional magistrate had exonerated the respondent of any responsibility or culpability in the said incident in his report dated so and so. Evidently, the government kept quiet for a number of years in view of the said report. Only much later, when the respondent's case was to come up for promotion to the post of Deputy Inspector General of Prisons, that the matter was raked up and charges served. The government had practically decided not to proceed against the respondent. It was raked up after several years, only with a view to deny promotion to the respondent. The action of the appellants is thus clearly vitiated by malafides. The respondent was not the superintendent of the jail at the relevant time the incident took place. It also appears that the officials who were said to be responsible along with the respondents have been exonerated. The inquiry cannot proceed only against the respondent. These are the three circumstances on which the High Court had interfered with the proceeding. But paragraph 7, your lordship will find the Honorable Supreme Court had recorded the charges to indicate the gravity of the matter, the seriousness of the charges. The gamut of allegation was that because of his recklessness, the prisoners had fled, escaped from the prison, and
So according to you, in that particular case, charges is very grave.
Yes.
For which the Honorable Apex Court has interfered.
Yes. Now, this case, I'll submit one case before your lordship. It was also placed before the Honorable Tribunal. This Chamanlal Goel case was also considered by the Supreme Court in a later decision, and that judgment was placed before the tribunal. Before I take your lordship to that judgment, what I will submit at this moment, here also your lordship will find this is in a very schematic way, my lord, the things have been delayed.
So that he doesn't get the promotion.
So that he doesn't get the promotion. And what is the allegation? Over a period of 4 years, you have taken hiring charges. Allegation is that you have availed hiring charges amounting to 1,98,000. That's as I said to your lordship earlier. A class 1 gazetted officer spending something around rupees 5,000 a month on transportation charges. Is it something very unrealistic or unreasonable to think? And on this kind of a frivolous charge, my lord, his promotions have been denied. Taking a help of this thing, he has not been given promotion. Ultimately, he had to retire without being promoted. The promotion case is pending, my lord, and if something happens to his credit, perhaps he will get the notional benefit. That's all. And your lordship, this, as I said, this Chamanlal Goel case has been referred. Your lordship will kindly come to the other judgment, which is the cases that were submitted from the applicant side, page 109. Page 109 is the case State of AP versus N. Radhakishan. And page 112, paragraph 4. This was the pinpointed question that was gaining court's attention. Paragraph 4 at page 112. Whether the delay did vitiate the disciplinary proceedings, and if the tribunal was justified in giving the directions aforesaid, we may refer to the sequence of events. So this was the question that was being considered by the Honorable Apex Court. Now, if your lordship will kindly come to page 121, paragraph 18, Chamanlal Goel's case is discussed. It will on the left hand side. Paragraph 18, State of Punjab versus Chamanlal Goel. Has your lordship seen this? Now, after discussing the case, paragraph 19, your lordship will kindly consider at page 122.
Yes.
It is not possible to lay down any predetermined principles applicable to all cases and all situations where there is delay in concluding the disciplinary proceedings. Whether on that ground the disciplinary proceedings are to be terminated, each case has to be examined on the facts and circumstances of that case. The essence of the matter is that the court has to take into consideration all the relevant factors and to balance and weigh them to determine if it is in the interest of clean and honest administration that the disciplinary proceedings should be allowed to terminate after delay, particularly when the delay is abnormal and there is no explanation for delay. Here is also a case, Miller, there is absolutely no explanation. The delinquent employee has a right that disciplinary proceedings against him are concluded expeditiously and he is not made to undergo mental agony and also monetary loss when these are unnecessarily prolonged without any fault on his part in delaying the proceedings. In considering whether the delay has vitiated the disciplinary proceedings, the court has to consider the nature of charge, its complexity, and on what account the delay has occurred. If the delay is, this is very important, if the delay is unexplained, prejudice to the delinquent employee is writ large on the face of it. Well, a submission has come that it will cause no prejudice to me if the proceeding is allowed to continue, and I will be entitled to take all sorts of defenses. Well, this is the wording of the Honorable Supreme Court, that the unexplained delay itself is a prejudice caused to the delinquent employee. It is the basic principle of administrative justice that an officer entrusted with a particular job has to perform his duties honestly, efficiently, and in accordance with the rules. If he deviates from this path, he is to suffer a penalty prescribed. Normally, disciplinary proceedings should be allowed to take their course as per relevant rules. But then delay defeats justice. Delay causes prejudice to the charged officer unless it can be shown that he is to be blamed for the delay, and when there is proper explanation for the delay in conducting the disciplinary proceedings, ultimately the court is to balance these two diverse considerations. Now, your lordship's query was that what is your explanation for this delay? Not a whisper in the WS that this was the reason, because they cannot make out a case where there is no case. The next case that was pressed before the Honorable Tribunal is at page 124, the PV Mahadevan case, and in that case, page 125, your lordship will finally see. The appeal is directed against the common order passed by High Court of Madras,
The
and
judgment was cited by whom?
this was cited by the applicant, that is the respondent before your lordship. It was cited before the tribunal.
It has been considered by the Honorable Tribunal.
Yes, but the finding that I want to draw your attention to is at page 128, paragraph 10, placitum G. Well, the kind of submission that has been made in the present case was also made in that case, placitum G. There is no acceptable explanation on the side of the respondent explaining the inordinate delay in initiating departmental disciplinary proceedings. Mr. R. Venkatramani, learned senior counsel, is appealing for the respondent. His submission that, well, this is similar to our case, the submissions in our case. His submission that the period from the date of commission of the irregularities by the appellant to the date on which it came to the knowledge of the housing board cannot be reckoned for the purpose of ascertaining whether there was any delay on the part of the board in initiating disciplinary proceedings against the appellant, has no merit and force. The stand now taken by the respondent in this court in the counter affidavit is not convincing and is only an afterthought to give some explanation for the delay. Exactly, my lord. Here also they are now saying that because you submitted the written statement late, and because we came to know from the CBI only that a case is pending, so those periods cannot be taken into account. It has been rejected in categorical terms by the Honorable Apex Court. And the other judgment on the Lordship's file is at page 130. It was also a case incidentally done by me only. Paragraph 11 was the finding of the Honorable Division Bench of our High Court, at page 133. There was also a case of delay of about 12 years. And paragraph 11, your lordship will find the writ petition preferred by the Union of India against the judgment of the CAT was under consideration. As regards the first point on inordinate delay and unexplained delay, the apex court in a catena of decisions have, in no uncertain words, held that it would be unfair to permit the departmental proceedings to proceed further at a late stage or at a distance of time, which would be prejudicial to the person concerned. In the instant case, on the alleged irregularities against Bamintadi pertaining to the period April 2002 to February 2003, the memorandum of charge was issued on 5th of March 2014 or 7th of March 2014. That is at a distance of 12 years. Here also the alleged period are from 2008 and you submit the charge sheet in the year 2017 after a period lapse of 9 years. The only explanation rendered by the petitioners is that since initiation of a departmental proceeding is a very serious exercise and involves threadbare examination of the materials available, as such care has to be taken to ensure that an innocent is not subjected to harassment nor an errant officer escapes punishment because of hasty and scantily deliberated decision in a given case. This explanation to justify the delay is weak, uninspiring, and made as a matter of course. No cogent explanation is set forth to give the least benefit of credence to the said explanation. Not to be left without mention, proceedings had taken place in the interregnum at the instance of CBI and DRI, which concluded in favor of so-and-so. Most pertinently, it is not the case of the petitioners that the department was not aware of the alleged irregularities until 12 years had passed. So merely by saying that we were not aware, wake up only after we were alerted by CBI, that will not help. Because I have shown the order of the tribunal in 2014, where they contested the case full length. The reference can be had to the following decisions of the apex court as to the fate of the disciplinary proceedings in the absence of any satisfactory explanation for the inordinate delay in issuing the charge memo, which decisions had been noticed and relevant extracts reproduced by the tribunal. My lord, then these two cases, P.V. Mahadevan, I have already read out to your lordship, and Bani Singh, your lordship knows. The irregularities which were subject matter of the disciplinary proceedings initiated by charge memo so-and-so is stated to have taken place in 2002-2003. Apparently, the department cannot feign ignorance and say that it came to learn of it only in the year 2014. This is belied by the very fact that the department was alive to the investigations made by the CBI and the proceedings before the DRI. It is not comprehended as to why it had taken more than 12 years to initiate the disciplinary proceedings. The delay itself goes to show that the department did not consider the matter as of any serious import affecting the discipline of the department. One observation of the learned tribunal, I will just read out to your lordship. Your lordship will kindly come to page 358. That will make it very evident that why they are operating against me in a very selective manner. Page 357, if your lordship will kindly come to paragraph 22. That will also indicate their demonstrative exercise against me. The claim of the applicant in the present application that 53 other officials of the said department also availed the similar service of hiring vehicle and purchasing of the railway tickets from the same agency, but no disciplinary proceedings was initiated against any of those 53 officials. The respondents in the written statement as well as argument submitted that there is no such CBI case has been filed against the said 53 officials. Hence, no such proceedings were initiated against them. Thus, it is candidly clear that the department is not bothering the so-called offense, if so done by any officials, until and unless there is no such criminal case. For example, CBI case proceeded against them. This is indicative of the modus operandi, because I was aspiring for promotion and I had to be obstructed. So one FIR comes and thereafter the things start happening against me in a very schematic manner. First, I was suspended. I challenged the order of suspension. Tribunal sets aside that order of suspension, directs for my reinstatement. Then the thing becomes clear that I will be eligible for further promotion in the year 2014 itself, because on 11/12/2014, the DPC sat for vacancy year 2013-14 and 14-15. So during this time, my case had to be considered. Now they did it, what they did, they put it in under seal cover by placing me under suspension. This has, the moment the suspension order goes and the next DPC sits, 6th of October, 6th of August, the suspension was, order of suspension passed. 20th of August 2014, it was challenged. This was set aside and matter remitted back. Thereafter, they come up with the charge sheet. And what is the basis of that charge sheet? The FIR by the CBI. Now, if your lordship will pick up the affidavit that I filed to bring on record the judgment of the Honorable Bombay High Court.
Just now. Please come to page number 203. Para 15.
203. With reference to para 5 of the way, the respondents.
Para 13, page 203. That's the reply of the union,
Yes,
which refers to para 4.10.
yes. Respondents respectfully submit that the case in respect of 53 other officials is different than applicant's case, since in case of 53 officials, CBI could not trace any evidence against them for providing undue help or advices to so and so. But in the case of the applicant, CBI in its investigation found that.
Please come to that finding which you have just placed before the court, that the finding of the tribunal, page 40.
That will be at that will be at page
Para 22,
358.
357.
Yes, 357. Yes. the respondents in the written statement as well as argument submitted that there is no such CBI case against, case has been filed against the said 53 officials.
And with regard to that, the Honorable Tribunal have indicated. Just on the pointed out.
Your Lordship took me to 203, page 203, paragraph 13.
No. You were putting that judgment of the tribunal.
Yes, 357, paragraph 22, end. The respondents in the written statement,
Yes.
last two lines.
Yes.
Respondents in the written statement as well as argument submitted that there is no such CBI case against the said 53 officials and no such proceedings were initiated against them.
Now, in your additional affidavit, the order of the
Bombay High Court.
Mumbai High Court.
Yes. Your Lordship will kindly come
Come
to
to page number 394, paragraph 50.
the deficit material in the charge sheet.
Yes, please read.
The deficit material in the charge sheet would not justify framing of charge against the present petitioner under section so and so. And also for the abatement of section so and so. Probably this is a specific reason why there is no criminal prosecution in respect of other officers who have also availed the similar benefit and who have been proceeded. This is perhaps a wrong, because it is admitted
That's
case.
what we have said, because if you see.
Perhaps who have not been, my lord, it would be- perhaps the
Yes.
not is missing.
And who have been proceeded department.
Who have, it ought to have been who have not been. Hello, it is their case, your lordship can ascertain from them. It is their case that no disciplinary
That is why
proceeding.
we have asked you to read that paragraph 22 of the
Yes.
reply. That is where they have said there is no proceeding, criminal proceeding.
Yes. But it is an admitted position, my lord.
I do not know whether there is a departmental proceeding or not.
No, it is not. I can say with utmost sincerity, my lord. My friend is there. Your lordship can ascertain it from her that no DP was against the other 53. But in the preceding paragraph, page 14, my lord, what I wanted to draw your lordship's attention to, there is absolutely no connection. The aforesaid information supplied clearly revealed that Sankalp was not a registered firm. Your lordship has said
That we have seen that.
page 90, your lordship had said, read that, supplying products to CSD, and if it is not so, there is no question of giving any consultancy by the present petitioner in favor of Messrs. Sankalp. The prosecution has failed to establish any business transaction between Sankalp and the petitioner, which could have given rise to a possibility of showing any official favor to the co-accused so-and-so. In order to establish the charge under section so-and-so, it is imperative to establish the official function, and it must necessarily involve a business transaction being transacted or about to be transacted by a public servant who obtains or attempts to obtain for himself any valuable thing without consideration or for a consideration which he knows to be inadequate. However, in the present case, since no such connect in form of a business to be transacted or already transacted between CSD and Sankalp has been brought on record, the prosecution is merely based on assumption. The learned judge, while passing the impugned order, has assumed that the bribe was paid for advising, offering consultancy for sorting out the queries in CSD related matter and time release of payment against supply in favor of Sankalp. Not a single document in the charge sheet established any amount being payable or amount being paid in favor of Messrs. Sankalp by CSD. Even if I turn to the accusation that different agencies supplied their goods to Messrs. Sankalp and who in turn supplied it to CSD on commission, the prosecution has failed to establish that any commission was received by Messrs. Sankalp, either from the entities with whom there was a consultancy agreement or at the hands of the CSD. There is absolutely no material, my lord. That's why, my lord, the charge sheet itself was quashed. So therefore, my respectful submission will be that since your lordship has seen that the foundation of this disciplinary proceeding is the FIR filed by the CBI, and the FIR has gone. That is all the more another reason, my lord, which has developed during the course of pendency of this case, that there is no substance in the disciplinary proceeding.
What do you have to say, Mr. Ratto, regarding the preponderance of probabilities? As you know, that disciplinary proceeding and the criminal charges are to be proved in two different modes.
No,
Right.
yes, my lord.
So in the disciplinary proceeding, it is preponderance of the probabilities.
Yes,
Whereas in the criminal it is beyond reasonable doubt.
yes,
So the charges, criminal charges were set aside
yes,
by the High Court, right?
Yes.
Quashed.
yes.
But what about the disciplinary proceeding pertaining to preponderance of the probability?
My lord, that stage is yet to come. Because in the disciplinary proceeding, the stage of preponderance probability will only come when the proceeding is allowed to continue.
Yes, Mr. Sharma.
And one thing to your lordship's query, my lord. Of course, I have not come with that judgment today. The Honorable Apex Court has said so in many decisions that if during pendency of disciplinary proceeding, a criminal court acquits honorably, not a benefit of doubt, acquits the delinquent honorably, that will,
Very much.
that is a-
Now, when the
yes,
charges have been quashed, do you
Yes.
think he has been acquitted honorably?
no, quashing of charges is, I will say, my lord, it is on a much higher footing because acquittal comes after trial. Here, the Honorable Court has said that there is no substance at all to go for trial.
We may differ from that decision
Yes,
because in that particular case, in which the Mumbai High Court has decided,
yes,
it is a fact, there is no such gratification because they failed to prove there is no such document, right? But here is something else.
no. Bombay High Court has said, my lord, I may just
Mumbai High Court has quashed the proceeding because there is no such material.
no. Bombay High Court has quashed not the proceeding, quashed the charge sheet.
Right.
Because I challenge the charge sheet that there is no substance in the charge sheet on which, my lord, a trial may commence. The trial did not commence at all. It is much before conclusion of the trial that the charge sheet has been quashed. So therefore, in my respectful submission, it will stand on a much higher footing because acquittal in a trial is, my lord, is a case where there is prima facie opinion that the charge sheet is justified.
You know, against which that whether the authorities have preferred any SLP or not. But if we go through the judgments of the Apex Court regarding
But-
the discharge,
Yes.
right? You'll see certain other cases because it is to the subjective satisfaction of the trial court taking the cognizance of the offense.
Yes.
Right. In that purpose, whether the High Court exercising the power under Article 482, sorry, the CRPC 482, whether to that extent, because if you see the way this particular judgment, let us assume this, we're
Yes.
not passing any on this on the merit, but if you see this judgment passed by the Honorable by High Court, have dealt with everything, but in a 482, whether to that extent you can go
No,
in terms of the, because if you read the judgment of the Mumbai High Court, it is something different.
no, it has
They
gone
have
in.
dealt with each and every document charge and whatever.
No,
It's
I
more
am
like
saying
a-
why it had gone so. Because when the charge sheet was filed, at this stage of framing of charge, my lord, I filed an application under 227.
That is the reason we are asking you.
No,
We are asking you that's criminal case and a disciplinary proceeding stands in two different footing. And if a person is not honorably acquitted, then definitely the question of disciplinary proceeding may go on. But while discharging the petitioner here or setting aside the charge sheet, see,
no, my lord, I may just explain it this way. my lord. Lord, honorable acquittal and discharge
not equal, not same.
are not equal, but these come at a stage after the trial is conducted.
That is why.
Now, a trial is when a trial is conducted, my lord, it is prima facie believed that the charges are genuine. Then only the trial is progressed. Here is a stage, my lord. Here is a case, my lord, where the Honorable Court has said that there is no substance in the charge sheet at all. I filed an application under 227 CRPC for not framing charge. The special court rejected my application. As against that application, I went before the High Court in 482.
That is absolutely different kind of decision.
Yes.
Exercising power under 482.
Because Honorable High Court has exercised the 482 power in the context of my petition under 227 CRPC. Now, 227 CRPC petition was rejected by the special court. Therefore, my lord, the Honorable High Court had to go into these details. And the fact of the matter remains that today there is no charge against me. And this charge has been the very foundation of the disciplinary proceeding. The first document in the charge sheet is the FIR. Now that FIR is gone. And the man is retired. Now it is maybe 3 years. He is retired now. You are going to inquire something about him, which took place 15 years back, 2018. 2008.
Come back at one and hear Ms. Sharma, then we'll decide.
Obliged. So, my lord, as I said, the trial itself. So therefore, this will have a much better effect than the order, than an order on acquittal or discharge. In that view of the matter, my lord, the interference of the honorable tribunal with the charge sheet in the departmental proceeding does not call for any interference.
Where is Ms. Sharma? Isn't some other you? What over?
And one thing that I highlighted in the affidavit, the identicalness of the allegation. If your lordship will kindly come to page 380 at para 8. Page 380 at para 8.
C18.
380. 380 at para 8. That, as your lordship got it, that the respondent states that even a cursory look at the content of the charge sheet and the memorandum of charge referred to above would show that both are in relation to same incident that allegedly took place during November 8 to June 2012 and based on exactly the same set of facts and evidence. The listed documents number 1 to 17 by page 76, 78 of the writ petition appended to the memorandum of charge are exactly the same as appended to the charge sheet by page 222 to 224 of the writ petition, wherein these find place at serial 124. My lord, I have indicated the serial numbers in the charge sheet. Exactly same thing. That the respondent submits that on the face of records, it is apparent that the disciplinary proceeding is hopelessly delayed by 9 years, which by itself is prejudicial in nature. The allegation in the memorandum of charge is precise reproduction of those in the charge sheet. Besides, the departmental proceedings is based exactly on the same set of facts and evidence. This apart, the order of discharge passed by the Honorable Bombay High Court as referred to herein above has dismantled the charge sheet dated so and so 21/7/2014, which is the very foundation of the memorandum of charge dated 21/4/2017. It is humbly submitted that the charge is on a much the discharge is on a much higher pedestal than acquittal. In such view of the matter, interference with the order of the learned tribunal, as has been sought for by the petitioner, and thereby to allow them to continue the proceeding, would constitute abuse of process of law and cause undue hardship to the respondent, who has retired from service on 30 November 2000. It will be 2021. 21. There is a typographical error here. So that is my case.
Mr. Doctor, this affidavit not in the format or what? Because his name, son, father, son of, is nothing is mentioned in the top.
Just
Straight
stamp.
away, just like in reply, because it's an affidavit.
Yes, this ought to have been there. This ought to have been, but then it came from
Maybe.
Bombay, therefore, or maybe they do it in that manner.
Has to be there.
But otherwise, on the top, it ought to have been there as we follow in our format.
That's what you said. It's not in the format or what? Anything else, Mr. Doctor?
No, that's all.
Lordship, I just want to reply to 2-3 points, Lordship.
Sure.
That Punjab and Haryana High Court judgment, Lordship, then page 187, Lordship, paragraph 23. Although it is set aside, Lordship, paragraph 23 read as Lordship, in the above backdrop of the aforesaid discussion, we are of the view that the impugned order dated 6/8/2014 cannot sustain in its present form as it doesn't show application of mine and therefore the same is quash and set aside. The matter is remitted back to the respondent to give a fresh look in the light of what we have observed herein above and pass a reason speaking order in accordance with rules and law. So, Lordship, its opportunity was given to the respondent, Lordship, here.
No, this is suspension order. It is not
Yes,
a
Lordship.
suspension.
Suspension order, Lordship. But suspension order, while set aside, Lordship, also remitted the matter back to the authorities, Lordship. Then, Lordship, second submission of my learned senior is that he being a class 1 gazetted officer, so 5,000 we have to look in the context of 2008 and 2012, Lordship, and total amount also, Lordship, of around 2015 to 12-15 years ago, Lordship, 12 to 15 years ago. So amount that he stated that class 1 gazetted officer 5,000 a month, that we have to look into from 2008 angle, Lordship. Thirdly, Lordship, that prematurity, Lordship, till date, Lordship, nothing has against him, Lordship. So no grievance, no locus standi of the petitioner at this stage, Lordship. CBI case is on Prevention of Corruption Act, and here we have this under conduct rule, Lordship. And regarding that 53 official, Lordship, those 53 officials, Lordship, may have hired or may have taken railway ticket, etc., from that agency's, Lordship. But in the case of the petitioner, Lordship, those amounts were paid by Sankalpa Trade Consumer Private Limited. So if there is nothing, Lordship, why another agency? That is, Sankalpa is not a hiring agency also, Lordship. It is paid by him for the petitioner only. So for others, we have no objection buying from any of the authorized agent. But here the payments were made by the Sankalpa Trade Consumer, whereas in other persons, Lordship, there is no such evidence, Lordship. So they, in reply that I have to state that much, Lordship. Others we have already discussed.
Ms. Sharma. Come to 109. That's the judgment of the Honorable Apex Court
Lordship.
in the case of State of Andhra Pradesh versus and Radhakrishnan, right? Now come to page 122. Para 19.
Lordship. It is not possible to lay down any predetermined principle applicable to all
Read
cases.
very slowly and tell us about the petitioner. Yes.
It is not possible to lay down any predetermined principle applicable to all cases and in all situations where there is delay in concluding the disciplinary proceeding. Whether on that ground the disciplinary proceeding are to be terminated, each case has to be examined on the facts and circumstances in that case. The essence of the matter is that the court has to take into consideration all the relevant factors and to balance and weigh them to determine it. If it is in the interest of clean and honest administration that the disciplinary proceedings should be allowed to terminate after delay, particularly when the delay is abnormal and there is no explanation for the delay. The delinquent employee has a right that disciplinary proceedings against him are concluded expeditiously and he is not made to undergo mental agony and also monetary loss when these are unnecessarily prolonged without any fault on his part in delaying the proceeding. In considering whether the delay has vitiated the disciplinary proceeding, the court has to consider the nature of charge, its complexity, and on what account the delay has occurred. If the delay is unexplained, prejudice to the delinquent employee in writ large on the face of it, it could also be seen as to how much the disciplinary authority is serious in pursuing the charges against its employee. It is the basic principle of administrative justice that an officer entrusted with a particular job has to perform his duties honestly, efficiently, and in accordance with the rules. If he deviates from this path, he is to suffer a penalty prescribed. Normally, disciplinary proceedings should be allowed to take their course as per relevant rules, but then delay defeats justice. Delay causes prejudice to the charge officer unless it can be shown that he is to blame for the delay or when there is proper explanation for the delay in conducting the disciplinary proceeding. Ultimately, the court is to balance these two diverse considerations.
So this is the observation of the Honorable. This particular paragraph, the Honorable Apex Court has cleared everything. Now, whether this writ petition filed by the Union can stand on the basis of the observation made by the Honorable Apex Court.
Lordship, whatever I have already submitted, I cannot.
Yes, we have just read, right?
Yes, Lordship.
Tell us.
What is
Yes,
their
suffices.
Lordship in WS and what is the stand? I have to go by that only, Lordship. I cannot improve now, Lordship. So it's Lordship, both ways, some judgments here and there. The facts are different in some cases. Delay also there has to be seen from the facts of each and every case, Lordship. So it's for your Lordship to decide, Lordship. What
You have to tell us.
So,
In your case,
delay is there, Lordship. Grounds, what is sought in the written statement, that those are there, Lordship. But
that
then
is the reason the Apex Court said it large. That means why he does not want to promote the petitioner, block him from his promotion.
Lordship.
But to block him from promotion.
But,
That is the reason they have, maybe you have initiated a disciplinary proceeding at that stage.
But 2 years, he also waited from the date of appointing the inquiry officer. Perhaps that 2 years is also a delay, 6 months, 2 years, these things also has to
That
be.
doesn't lie. See the judgment of the Honorable Apex Court, if I have rightly remembered. Let's see. Forgot a citation. There was a Okay. The gist of that case was there was a delay in filing the appropriate application by the persons whose land was acquired. So matter ultimately went to the Honorable Apex Court. They are the Union of India. It's a matter where the lands were acquired for the New Delhi. The old case. So it's an agricultural field in New Delhi. So the lands were required for expansion of new land. In that circumstances, the court, the Union of India said that the petitioners as have approached the court belatedly. Their cases should not be considered, and there has been whatever have been paid to them is paid is final. And ultimately, there was a finding that there are some applications of the landholders pending before the authority, which are not taken into consideration. In that particular judgment, it was three judges' judgment laid down that the question of delay, raising the question of delay on the part of those persons, aggrieved persons, cannot stand because it was the concerned authority who himself delayed the matter. So they cannot raise the issue of delay with regard to the claimants. That was the finding of the apex court. Just not getting it, I came nearby, but somewhere it was in 1994 or 1995, some supplementary SSC. So you admit the fact that there was a delay of at least 4 years. Forget 2008, because after the FIR and after the search sheet was filed, only when the search sheet was filed in the CBI case, you have filed it. After that, after 4 years, after 4 years thereafter, you have filed it, search sheet, initiated the disciplinary proceeding, and there is no explanation.
Apart from what other already discussed, there is nothing else.
So to that extent, you admit. There is another observation by the court in that particular paragraph 19. What about the extent of seriousness in the part of the disciplinary authority? So go to that para 19, you will see,
Yes, Lordship, I have done through it.
right?
Yes.
So how serious you were to proceed with the disciplinary proceeding? The Honorable Apex Court subsequent to these decisions, there are certain decisions are there, plus what we have come across 8, 9, 10 such decisions in there, where even if it is a delay, but not inordinate delay, and if the charges are grave, because disciplinary proceeding in service and a criminal proceeding are two different. So, in that circumstances, if the delay is there, but it is not inordinate delay. How do you define inordinate delay and delay? So, the action on the part of the petitioner hearing in initiating the disciplinary proceeding against the petitioner, you have to show from somewhere that there was no such lacuna on your part to proceed with. You have said that you did not receive the information. Forget that 6 months delay in filing the reply by the petitioner. Right? But everything starts from the initiation of the disciplinary proceeding. Maybe it is from 2008 to 2012. Now, from 12 to 2017, how do you explain? There is no explanation at all. Because search in the CBI case was filed in the year 2012. Or the letter of the CBI that was initiated to you, sent to you that it was in 2013. You have immediately replied. How do you do that? You are asking us to court to decide, right? So, in terms of this observation, it is the court to balance these two diverse considerations. Now, show us.
It's Lordship, whatever is there, Lordship.
Mr. Doctor, just tell us one thing. belong to CSD of the Defense Department.
Yes.
As we all know that any employee serving in the defense or in the judicial,
So he is in the civilian.
maybe,
Civilians are all jurisdiction is CAT.
doesn't matter. But within the jurisdiction of the Defense Department, CSD comes under Defense Department,
Under defense, yes.
right? It is a disciplinary force where in the civilian or in the defense sectors, just like the judicial officers. There's a finding here. Ms. Sharma, read para 6, then para 9 of your reply. It starts at page 196. Para 6 and para 9.
With reference to para 4.2 of the OA, the respondent respectfully submit that the appellant has not brought the true fact before the honorable tribunal. It is true that charge sheet under CCA issued by memorandum number so and so dated 21 April 2017. It may be noted that the applicant has never disclosed progress of CBI case against him to respondent number 3. It was only when respondent number 3 approached CBI Mumbai CBI 5 so and so dated 4/5/2016 intimated that cognizance on charges has been taken by CBI court, Mumbai on 24/7/14. Charge sheet under CCA rule was issued only thereafter after following due procedure. Therefore, the applicant himself is responsible for delay as he alleged and now wanted to take advantage for concealing information from respondent and honorable tribunal while seeking relief. Further applicant represented against the charge sheet dated 21/4/17 under so and so on 29/9/17 and 27/11/17. Therefore, he took more than 6 months to send settlement of defense against the charge sheet. Thus, the applicant has not approached the honorable tribunal with clean hand. So far as applicant's claim of negative equity with case of 53 official is concerned, it is submitted that there is clear distinction in case of applicant and 53 other CSD official as CBI could not trace out any evidence against other official for providing undue help or advices on official matters to anyone. But the appellant's case, it is different. As per case filed in so-and-so, Sri Milind Binayak Gwalikar was director of so-and-so, who was acting as an agent of different companies who supplies goods to CSD. And there was an agreement with the CSD limited listed companies and so Mumbai pertaining to supply a product by the companies to CSD for logistics support, and in return, Sri KK Srivastava helped Sri Milind Binayak Gwalikar for giving him advices consultancy in sorting out the queries of CSD related matters, timely release of payment against supply in favor of so and so. That Sri Milind Binayak Gwalikar was thereby has committed crime lordship. So, a officer applicant has not brought the true facts, taking more than 6 months time.
Completely para 6.
Lordship. Case against him to respondent number 3. It was only when respondent number 3 approached CBI Mumbai. CBI so-and-so by letter dated 4/5/16 intimated about taking cognizance of charge sheet filed against the applicant by CBI Court Mumbai. Charge sheet under CCS CCA rule was issued only thereafter after following due procedure. Non-cooperation and concealment of vital information by applicant has delayed in filing charge sheet under so-and-so. So far as applicant claim of negative equity with the case of 52 official is concerned, it is submitted that there is clear distinction in case of applicant, and this is the same logic. Same thing.
Come to para 9.
So the respondent deny the averment and submit that they have followed well-established procedure under law. However, respondent has no comment for other contention of applicant given in said paras as case under PC Act is sub judice in CBI court. Further, the applicant has wrongly calculated 12 years. It may be noted that the applicant has never disclosed progress of CBI case against him to respondent number 3. It was only when respondent number 3 approached CBI court on 4/5/16 intimated about cognizance taken by CBI court. Mumbai for charge sheet filed against the applicant. Charge sheet so-and-so was issued only thereafter after following due procedure. Further, applicant sent his statement of defense so-and-so 6 months. Therefore, applicant himself is responsible for delay as he alleged and now wanted to take advantage of for concealing information from respondent while seeking relief.
With regard to this particular observation, made specifically in the reply to the application by the present petitioner. Page 197, letter part of 197 and 198. Mr. Doctor. What do you have to say?
190.
7. Does that what organization?
Page 197,
Letter
that is
part.
the inner page 8 of the reply of the Union of India to the application filed before the tribunal.
Yes.
The 9th line from bottom. Does the applicant?
Applicant has not approached the honorable tribunal. It is for.
No, please go ahead.
Yes. So far as the applicant's claim of negative equality with 53 officials is concerned, it is submitted. There is clear distinction in case of applicant and 53 other CSD officials, as CBI could not trace any evidence against other officials for providing undue help or advices on official matters to anyone. But the applicant's case is different. As per case filed in CBI Mumbai so-and-so, para 3 and 4, within Vinayak Govilkar was director of so-and-so, which was acting as an agent of different companies which supplies goods to CSD, and there was an agreement with the CSD listed companies and Mrs. So-and-so. As per para 821, Sri Milind Vinayak Govilkar was having official dealing with Sri KK Srivastava so-and-so, pertaining to supply of products by the companies to CSD for logistics support, and in return, Srivastav has helped so-and-so by giving advices, consultancy in sorting out the queries of CSD related matters. Timely release of payments against supply in favor of Messrs. Sankal Consumer Products Private Limited. Further, para so-and-so stated, this is a.
We understood that's a part of the CBI SRC.
Yes.
Now, next paragraph.
It is submitted that the charge sheet under so-and-so was issued after following due procedure. Since the respondent being Group A officer, appellant has not brought the true facts before the honorable tribunal. It is further submitted that the charge sheet under so-and-so issued by memorandum note so-and-so, for which applicant given statement of defense on so-and-so.
That we are not considering. That 6 months will not come into the picture. What we want to know from you, Mr. Doctor, at this stage, if we come back to again the judgment of the apex court at para 19, page 122.
122. Yes.
There the apex court clearly laid down at para 19 that it is the basic principle of administrative justice that an officer entrusted with particular job has
to perform his
justice.
duties honestly, efficiently, and in accordance with the rules.
So, being an employee of the discipline force, and there is no response with regard to the observations in the reply, that being the person concerned, the AGM headquarter Mumbai, pertaining to supply of products by the companies to the CSD for logistics support. And in return, the person concerned of the Sankalp Consumer Products Private Limited, helping, giving advice and consultancy in sorting out the queries, the CSD related matters, for which some help was sought for by buying tickets or by providing hiring vehicles, for which the payment was made by this Sankalp. Whether the authorities cannot issue any disciplinary or cannot initiate any disciplinary procedure against you.
Well, these statements that I have just now read in paragraph 6 and 7, these are contents of the CBI charge sheet. It is not their case.
It is true.
Now,
That is the reason we are asking you. It is an admitted position that only after filing of the charge sheet, the CBI case, when they came to know, the cognizance have been taken in the CBI case, they have admitted the fact. After filing of the charge sheet, the concerned trial court, the CBI court has taken cognizance, and only when they have come to know that in 21/4/2017, disciplinary proceeding have initiated. So, now whether, just tell us, that circumstances, as if these things are there in that particular CBI subsidy, for this reason, giving you the browser numbers and everything in details, all the relevant documents, whether the authorities concerned can or cannot proceed with the disciplinary proceeding against you. Keeping in mind that the applicant belongs to disciplinary force.
no, I'll slightly differ on this aspect. The applicant is not a member of a discipline
No.
force.
He is not a member of a disciplinary force. Sure.
He is not a member of a discipline force. He is a civilian employee under the Defense Ministry.
So,
Had he been a
according
discipline-
to you, a civilian employee serving in a disciplinary force doesn't belong to discipline force.
No, there are two distinctions, my lord. In the defense establishment also, as also in the state police.
One straight away comes under a defense service.
One
right?
is known as combatized force and one is non-combatized.
Right.
This is within the fold of the defense. Now, within the fold of the defense, there is a third category, my lord, which are all civilian staff. They have got nothing. No,
That is why their matters are before the tribunal.
yes, otherwise it would have gone
Arms
before the
tribunal.
arms tribunal. The
Being a civilian in a defense service, whether the person concerned will be the employee concerned will be belongs to discipline force or not.
I won't say he will belong to member of a discipline force, because whenever to become a member of discipline force, my lord, he will have to be a member under that particular service rules. This present PT applicant is governed by CCA rules, not by the Army Act or by the Army rules. So unless he is governed by Army Act or Army rules, he will not be a member of discipline force. He is a civilian employee and therefore the civil rules
So
are,
your contention is since he belongs to CCS service.
Yes.
So he is not belong to that defense.
no, he may be under the ministry, he may be under this defense ministry, but not governed under that act or rules.
Fine.
And so far as these contentions are, as has been reflected in the paragraph, these are in verbatim reproduction of this charge sheet in the CBI. And that charge sheet has gone. That charge sheet is no longer subsisting now. Now the question is that whether on these facts, at this distant point of time, the inquiry could have been continued. The other aspect of the matter, my lord, may consider, they are coming before your lordship challenging an order passed by the Central Administrative Tribunal. And as it has been laid down in the by Supreme Court, my lord, the challenge is only to the extent of the decision-making process. In the entire of the writ petition, they have not been able to pinpoint any error in the decision-making process of the tribunal. Had it been a case that the tribunal has not taken into account the relevant considerations and has passed the judgment on irrelevant consideration, the thing could have been a different, could have been little different. But there, in the entire of the writ petition, your lordship will not find one assertion that the decision-making process of the tribunal has been flawed. And it is not the, the jurisdiction that your lordships will exercise in the matter is not the appellate jurisdiction as such. It is only a judicial review. Because in the judicial review, it is only the decision-making process which is to stand your lordship scrutiny. The case that was projected by the applicant, by the petitioners, that was taken into account by the Honorable Tribunal. And the Honorable Tribunal, by referring to the circumstances as well as the judicial pronouncements holding the field, has decided the matter in favor of the applicant, who is the respondent before your lordship now. So there is no error in the decision-making process, which may otherwise warrant your lordship's interference with the case.
Not MS, visitor server. This is a SIP of the petitioner. Mr. S. Doctor and its senior counsel. Assisted by whom? Arvind. That counsel. For the respondent. Other claim.
Lordship is CAB major
Obliged.
obliged. Lordship. Obliged.
Accommodation want to accommodate for you. Stand with the want to profit I accommodate for you. Not 225. Map legal lordships. Item number 1, my lord, my learned friend says he did not have any copy. So my lord, maybe item number 1 may be taken up another day. 2 may maybe take possible lordships.
Sharma, you don't have a copy?
Lordship.
He told
Any
me-
date, Lordship.
This is for admission only, right?
Matter of 17 Lordship.
One seventh. Have it on seventh.
May I please, your lordships?
Yes.
In this case, lordships, petitioner's father adduced evidence, petitioner also, land revenue office also, and government secretary also. There is state neither appeared nor cross-examined the petitioners. And here petitioner discharged her burden, lordships. Impugn order is at page 65. May I take your lordships? Bhutan list 1966, page 15. Page 15, Bhutan list 1966. Electoral roll of Balpara West LS lordship. Village Romari. Number 1, Basirali Sheikh is the uncle of the petitioners. Basatun Nessa is the grandmother. Habibur Rahman is the uncle, and Sikandar Ali is the grandfather of the petitioner. And then lordship will find page 17, Bhutan list of 1970. Uncle's name first, Basir Ali. Basatun Nessa, grandmother. Habibur Rahman, uncle. Sikandar Ali, grandfather. Sikandar Ali. Petitioner father's name appeared in the Bhutan list 1985 at page 19. Along with the father, father's name appeared along with his father, that is grandfather, the petitioner, grandmother, uncle, all of them. Village is Romari. Here appeared secondly grandfather, that is Basa Khatun, grandmother. Secondly, his father is Abed Ali, lordship, Abed shown. And Basir Ali is the uncle, whose name also appeared in the Bhutan list 1970, 66. Mujibur Rahman is the uncle. Father Dulal Sheikh, lordship 265. Serial number is the father, Dulal Sheikh. Mazeda Khatun 266. Petitioner is a married person, married at village Roma, married village Sakla, Bilpara. She was born and brought up at village Romari, married with Ansar Ali. It's a debuter case, lordships. And next Bhutan list, other Bhutan list father's name appeared.
Mr. Sharma, the voter list are taken up. This is together along with the voter list.
The voter case lordship, actually, it was just inclusions better, but in this case lordship, it was after it was referred to, I think lordship, it was referred to concerned fairness tribunal after
Declaration of the.
yes.
After striking down the orders tribunal, but it's a debuter lordship 97. The Bhutan list, her name appeared suspect. On that ground, case has been referred IMDT case lordship. A written statement is at page 40, lordships. Details family tree has been given. Petitioners also got Bhutan ID card also, lordship. Written statement, page 40. An amended written statement also provided because enclosing the age discrepancies appeared in the Bhutan list. This is it was amended, amended written statement submitted. Amended lawsuits. That is page 43. Cross part, page 51 lawsuits. Petitioners evidence is cross. Evidence is chip start from 47. Cross page is fine lawsuit 51. May I read lawsuits?
Just a minute. Yes, Mr. Bobby.
Yes, Lordship, page 51 is the cross part. My earlier my submission state did not appear. There is unfortunately said first one that case was item number 1 state neither appeared nor any. In this case appeared and cross-examined the petitioner's father. Your Lordship may take turn page number 51 of the cross part of the petitioner. Page 51 of the cross of the petitioner's lordship proceeding. Proceeding the Lalbani lordship. Made it. I was born and brought up at village Romari under Bosnam PS. I have not any document regarding my birth. I was given in marriage with one Ansar Ali, son of late Shiraj Ali of village Sopla, Bilpara about 15 years ago. And when I was about 18 years old, after 2 years of my marriage, I have given birth my first son, who is now about 11 to 12 years old. Sikandar Ali and Basatun Nessa are my grandparents who had died before my birth. Dulal Sheikh and Majeda Khatun are my parents who are resident at village Tiapara. Earlier they were Romari, subsequently shifted Tiapara. Their original place of my parents are at village Romari. They had shifted to village Tiapara under Pancharatna RPS about 15-20 years ago. Before my marriage, Basir, Habibur, Majibur are elder brother of my father. I am the second daughter of my parents. I have 7 brothers and sisters, including me. It is not a fact that my father, namely Dulal Sheikh, is the son of Sikandar Ali. Exhibit A is the certified copy of the voter list 1966 in the name of my grandparents. Exhibit B in certified copy of voter list 1970 in the name of my grandparents. Exhibit C is the certified copy of the voter list 1985 in the name of my parents and other family. Exhibit D is line certificate. Link certificate issued by Secretary Romari GP. Exhibit E electoral photo ID card compared with original. This is the petitioner's proceedings cross lawsuits. And in respect of father also there is evidence that his cross part is lordship will find page 57. Page 57 is the father cross part lordship. Father Dulal Sheikh lordship. Lordship got it. Page 57. I was born and brought up at village Romari. Tosidi Lalbanu is my daughter. My mother's name is Basatun. Majeda Khatun is my wife. I am illiterate and my daughter also never go to school. We are 4 brothers and 3 sisters, including me. I have 6 daughters and 1 son. Prosidi Lalbanu was married to Ansar Ali, son of late Siraj Ali, village Sakla Bilpara. Prosidi had 2 sons and 2 daughters. I am the voter of 1985 from village Romari. My parents are residing and casting their votes in Romari in between 1966 and 70. It is not a fact. I am deposing falsely. And DW3 is the LDL lordship. Land revenue Prosidi produced a sale deed in respect of her grandfather. Here is the case lordship file. There is no dispute at all regarding the evidence of the proceedings and the fathers, not disputing that Lalbanu is the daughter of the Dulal Shah. So, other but in respect of the DWD3 is the land revenue officer LD assistant appeared, where I produce a LD that has to be progressive. That is, I think, that I have exhibited also in respect of my grandfathers. But in that, I have not produced regarding mutation of certificate that it will come. If your lordship give a chance, I will place the mutation against that land also of my father lordship. That exhibit the DW4 is important. The secretary issued a certificate in favor of the Prosidi lordship. That is page 62. Page 62. I am at present serving as Panchayat Secretary of Romari GP under Formuja block. I have received summon and brought the official register and counter folio from which the certificate was issued. Exhibit D is the certificate issued in favor of Lalbanu, daughter of Dulal Sheikh of village Romari, who was given marriage to Ansar Ali, son of Siraj Ali of village Chakla Bilpara, under Bhagwan PS, bearing issue number so and so, dated so and so. Exhibit D1 is signature of the then Secretary Abdul Suban. Exhibit D2 is the signature of BDO Divannath of that locality, which is known to me. Exhibit D3 is the counter folio bearing serial number so and so, book number so and so, proved in original. Exhibit D is the register and serial number 4022. The name of Prosidi Lalbanu is recorded, proved in original. This certificate is not issued by me. I know Prosidi Lalbanu and the father personally and officially. It is not a fact. I do not know the Prosidi personally and deposing falsely. And here is the case lordship instant debuter is a case, and in respect of since the evidence I produced, it was not challenged, not disputed, no suggestions, no at all that the Prosidi is not a daughter of Dulal Shah. Prosidi's grandfather's name appeared in the Bhutan list of 1966-70 at village Romari. Prosidi's mother's name also appeared in the Bhutan list 1985, along with the grandfather of the Prosidi, grandfather, grandparents, and our uncles. There is no dispute at all that those persons are the Prosidi's grandparents, uncles, or father. Even no suggestions at all. In this regard, I may rely upon the decisions of the court lordships. In the case of Lordship Motiur Rahman, Union of India, reported 2020 1 GLT, 2020 1 GLT, 330. 2020 1 GLT, page 330. Let's say I am I'm placing, I am sorry, one, I lost one copy, one copy is available, 2 copies are available. Not required. Lordship. Paragraph 8, Lordship. May I read the paragraph 8, 9, 11, and 12. Paragraph 8, Lordship. In this case, Lordship, go ahead. Paragraph 8 in the Moti Rahman case, Lordship. In this case, the petitioner has produced the brutal list of 1966 of number so and so West Golpara LSU, where in the name of his father Ahmed Ali and mother Orijan Bibi was included. Certified copy of the electoral roll of 1966 is available on record as Exhibit A. The respondents have not disputed the correctness of Exhibit A. The petitioner has also produced certified copy of the electoral rolls of 1989, wherein the name of the petitioner has been entered as son of Ahmed Ali. There is nothing on record to dispute the claim that the petitioner is the son of Ahmed Ali and Porijan Bibi, who are living in India since prior to 1966. Mr. Payang has also submitted in his usual fairness that the respondents are not questioning the genuineness of the certified copy of the voter list for the year 1966 or 1989 produced by the petitioner. But the only dispute in this case is as to whether the name of Ahmed Ali shown in the electoral roll of 1999 is the same person who is the father of the petitioner. The name of the petitioner's grandfather, Manik Sheikh, is also mentioned in the voter list of 1966 and 1970. Paragraph 9. As mentioned above, the DW2, who is the brother of the petitioner, had categorically deposed that the petitioner is the son of Ahmed Ali and Porijan Bibi. Ahmed Ali, who had cast his vote on the basis of entries made in the voter list of 1966, the aforesaid testimony has not been assailed during the cross-examination of the witness. The respondents have also failed to lead any evidence in rebuttal. Moreover, in the reference sent to the Foreigners Tribunal, the father's name of the writ petitioner has been shown as Ahmed Ali. We are therefore unable to accept the contention of Mr. Payang that Ahmed Ali mentioned in Exhibit A is a different person. Paragraph 11. We also find from the record that the Learned Tribunal has declared the petitioner as a foreigner based on some minor discrepancies in recording of age and also for non-mentioning of the date of second marriage of the father of the petitioner. However, such discrepancies, in our opinion, are minor in nature and hence, even if found correct, would not have any material bearing in the outcome of this petition. Moreover, in the discharge of the Honorable Supreme Court rendered in the case of Chirajul Haq versus the State of Assam and others, in connection with the criminal appeal number so-and-so arising out of SLP number so-and-so, it has been held that minor discrepancies in recording the names, age, and address of the family members of the proceeding cannot be ground to doubt this case. Paragraph 12. Having regard to the peculiar facts and circumstances of this case, we are of the considered opinion that the petitioner has succeeded in establishing the linkage with his father, that is late Ahmed Ali, who was evidently living in India prior to the year 1966, and there are also sufficient materials to show that the petitioner had continued to reside in India since he was born. For the reasons stated above, we have the view that the interim order dated 2019-2017 is not sustainable in the eye of law, and the same is accordingly set aside. I'd like to relate another distance of this of the court lawsuits. Regarding non-challenged evidence, also not non-disputed evidence also, and Abdul Khalik versus Union of India, that is reported 2013 1 GLT 941. Two copies I have lawsuits provided.
2013 one.
2013 1 GLT 941.
We'll continue tomorrow. Or on
Yes, sir.
Tuesday next.
On Tuesday.
We'll continue
Tuesday,
on
or Tuesday, Lordship.
Tuesday.
Yes, sir.
Alage আছে।
2013.
2013 1 GLT 941.
2013 1 GLT
941.
941.
941.
Mr. Sharma, we have seen different views of the different division bench in this regard. Now, for the case that Matiur Rahman case, one of the bench considered that that Matiur Rahman was declared as a foreigner by the tribunal based on some minor discrepancies recording of the age and also of non-mentioning forget it. Now, thing is this. Tell us one thing. In various aspects, we have seen that name of the proceedings, father or mother, reflects in the voter list of 1985. And say in the 1985, the mother of the proceeding is about 33 years or 35 years. Some persons name figures in the 1966 voter list or 1977 projected as the grandfather of the proceeding. But again, from 70 to 85,
Yes.
the name of projected grandfather or grandmother of the proceeding is not found in any voter list.
Yes.
And again, in the 1985 voter list, say the proceeding's father or mother whose name is there 33 years or 35 years for the first time shown, along with proceeding's grandfather or grandmother. Different names. Whether these A's can be considered as a minor discrepancy?
No, not it.
I
Regarding,
think there is a proper judgment in this regard. Now, we know a particular case of the Honorable Apex Court.
yes, Lordship.
There, what happened? The grandfather's name was
Oh,
there.
Kapatullah
But three
and
things were
Kamatullah.
there. First of all, serial number, house number.
Yes,
The family members were there.
yes, Lordship.
Name of the person, only the spelling mistakes.
Only one is.
Only one word
Word.
of that particular spelling mistake. Right?
Kapatullah
And yes, Apatullah or something like that.
Kamatullah.
But not the entire things.
Yes, Lordship.
And in one voter list, only one word or their word is different.
Yes,
Again, in the third voter list, his name was again.
Yes,
original.
Lordship.
In that aspect, the Honorable Apex Court found that this man was shown to be the grandfather of the proceeding that Supreme Court just
Yeah.
should be considered as minor spelling
Mm,
mistake
Yes, yes.
or typography.
That can be considered.
Now,
Lordship.
whether some persons shown, not the names are not
Yes, Lordship.
totally different.
Yes, Lordship.
Ages are different.
Is different. Different.
There is nothing, no material placed before the tribunal. Why for the first time, the name of the proceedings father in the voter list of 1985 or somewhere that also without the name of the grandparents, only son, soon to be son of somebody
Yes.
at the age of 33 or 35 figure.
Hmm.
Again, there was no name of the proceedings projected grandfather or grandmother from 1970 to 80. How do you consider all these things as a
That
minor
cannot be
mistakes?
considered. Also. It cannot.
No, because you see, age is one of the major issues
Hmm.
in the voter list. The person may be named as ABCD, the first time voter.
Yes, sir.
His age will be quite. Let us assume it was 21 at the time of 11 point of time in 1989 as well. But he cannot be 61.
Yes, sir. Yes.
But just you have to clarify because we found in various judgments placed by the petitioners, considering these mistakes as a minor mistakes, whether these mistakes can be considered as a minor mistakes. That is why yesterday we asked Mr. Ali, unless the voters of their own
Lots.
doesn't file any application or correction of their name, their parents' name, their age,
Hmm.
right? It has to be accepted in totally.
Lots.
There is no other provision of correction of age
Lots.
or correction of their proper age specified, whatever in the voter list, to be considered as a minor or some mistake by the High Court or something under the exercise of the article to censorship. Can we do that? Because this is one issue what we found constantly. Representation of the People Act is a complete act. You cannot touch it.
Yeah.
But just saying that they are illiterate or whatever,
Hmm.
we cannot get ground. Cannot
No,
do
no,
it in the
that cannot be a ground.
That is why you are asking Mr. Bormia, please also because you are also court officer.
Lordship.
It
Yes,
is not there
Lordship,
that we are
yes.
have to.
In this case, may I suggest, Lordship, since village name, other family members appear, discrepancies are there minors.
See,
From the
basically,
SP may be suggested, Lordship,
If you
asked
read
to
the
verify
judgment-
whether 66, 70 members
if
are
you
same.
read the judgment of the apex court,
Lordship.
there is cases only a mistake of name of one or two particular English letter.
Yes,
In
no,
that
only
full
one
name,
letter.
Safaullah or whatever was there something was a mistake. That is in that prospect. But following that judgment, can we change the age, can we change the name or everything and be considered as a minor mistake?
Sometimes
I have
person said,
some doubt because
Ali not mentioned, that's why his name appear without
See,
Ali. Some voter appeared Ali. And these are
you can
the
understand, after
yes,
marriage
but
she becomes
village-
BB. Listen,
village.
listen.
Lordship.
After marriage, the lady becomes BB,
Yes, Lordship.
right? But in the voter list, the next voter list, even after marriage, you will not find her name as BB. But later point of time, you will find some BB. After the death of
Okay.
husband, she
Beva.
becomes Beva, right? You can understand
After
all this.
that, Lordship,
But
yes.
you cannot, when the evidence are like this, that husband expired, the father expired, or mother expired, let us assume the father expired, right? The mother name should have been, in the next voter list should have been Beva, but it is not there. Whether in that circumstances, we should accept the same.
Beva come after death of the
A
husband.
husband,
Yes.
so the procedure says, my father expired in these years. But in the voter list immediately thereafter, you or after 10 years or 5 years, you will not see the name Beva in the voter list. And thereafter, after 2, 3 subsequent voter list, maybe Beva is
Beva.
there. But by the time it becomes 2020, 2010 or whatever. So please look into all these respects. And as a court officer,
Lordship.
please apprise the court for proper adjudication. We are not here to help somebody or not to. not to help
Yes,
somebody.
yes, Lordship.
We are all here in the court of law to decide an issue,
Yes. And
right?
when the parents or father, mother gave evidence, that is very much
Friendly,
important.
look into all this respect. We are also asking
Very
you
much important
or your
regarding
other colleagues,
unless
Mr. Payang or Mr. Kolita.
father
or Mr.
says
Ali,
that person, my
because,
daughter,
this kind
son,
of thing, whether it will be a minor mistake,
That-
whether court in exercise of the
that
power under certiorari,
if someone not
just
question,
overcome that.
Lordship, may
Don't say no. Go to the judgment and tell us.
Lordship.
Right? Because there are certain provisions Supreme Court have specifically laid down. Say, for example, there is a provision of filing an application for compensation, higher compensation. In a land acquisition act earlier, there was a specific time period.
Yes.
So it is 6 weeks, let us assume. Now, in 6 weeks, that 6 weeks period, there are certain cases where 6 weeks period, they used to file application before the court of High Court, saying that limitation application, so that should be there and should be considered.
Mm.
It has happened, not only our High Court here, in other High Courts in Punjab and Haryana and other states also, it was considered. It's a benevolent, some people will be left out from the benefit of higher land acquisition compensation. Matter went to the apex court.
Yeah.
Right? The apex court said no court, in exercise of the power under Article 32 or under Article 226 can extend that period of 6 weeks. The reason is that particular act is a complete act. It provides the specific time.
Yes.
And there is no such provision that limitation act will be applicable for that particular act. Similar is the case here in the representation of the people act. It is a complete act where it provides for every particular provision, there is a time limit. And that time limit is a fixed time limit. So if it is a complete act, where is the power of the courts in exercise of Article 226 or under 32, and not under 32 or under 226, will be able to extend the time limit.
No.
Similarly, the names figured in the voter list, there is no such provision. That is why there is a provision for correction of the voter list.
No.
Right? So unless it is corrected, it has to be presumed and assumed that yes, this is the name. Can we, in exercise of that power, alter or consider?
Sorry to detain your lordship with second
No
application.
problem.
Yeah, lordship will find page 24 is the earlier order. This application was rejected when investigation was going on, and now charge sheet is submitted. So I came to know that observations made in this order, there are some other facts are there which I have come to know. Therefore, I have filed the second application. Primarily, the first application was rejected on the ground, lordship, that lordship probably remembers that there was an accident, and the accused number 1, he was in the car. And subsequently, the petitioner number 1, who is brother of the accused number 1, had telephonic conversation with him, being a brother, lordship. And what I find, lordship, it is the investigating officer submitted a written objection on the ground that the petitioner was earlier charged in different case. But it suppressed one fact, lordship, that in the said case, the petitioner number 1 faced trial and he was acquitted by the court on 11/10/2021 to 11/10/2018.
Just a minute. Sir, other please take this.
Lordship.
Have you gone through the record?
Yes. In the court below, my lord, charge yet to be framed. And these two persons shown as absconder.
Court has not considered him as on date. But I have gone through the entire record. The other petitioner, Rashid Ahmed,
Yes,
is a cousin brother.
yes.
And
First one is his own brother,
first one is own brother,
Hussein.
Hussein Ahmed. But against Rashid Ahmed, the other petitioner, I didn't find anything much.
No, yes. Actually, Ahmed,
Everything was with regard to that concerned driver who was arrested and later on released. On
yes,
bail.
yes.
And this first petitioner.
First petitioner, he was not present at the time of accident, my lord. Later on, he came.
No, the first petitioner was found from the CBI report that it happened like this. As per the eyewitness, the car passed through the victim
Yes,
to the national highway, then returned.
yes,
Then again, thereafter, when car stopped about 200 meters away from the
yes,
particular motorcycle. The motorcycle was parked 4 feet away from the
road.
4 feet and above away
Yes,
from the road. And he was in that particular, he was sitting in the bike,
yes,
putting his legs on that stairs of this particular banana shop. And this vehicle, the offending vehicle, after stopping the car for a few minutes, came in a very high speed and banged it.
yes, made this accident.
So basically, when the car passed off, the victim was sitting in the bike.
Nearby, yes.
And then
That's
he
all.
again returned.
Yes,
And again, this time he banged the vehicle knowing, seeing that the person was sitting in the bike. And then after committing the crime, he ran away. And immediately thereafter, his brother came and took him in his vehicle.
Yes.
Swift Desire. But nowhere I mentioned, there is no mention about the other petitioner
number
who
two.
happens to
Yes,
be a cousin brother of
yes,
both the accused persons,
yes.
right? The driver and this. And then everybody was saying that there are sufficient space to go by the road. In fact, that is the issue. And then the car came in a high speed for no reason because it stopped for a while, then it came in a high speed.
yes.
CDR report says just before the incident, 8 minutes prior to the incident, because car stopped. And that it was what happened. There was a direct conversation between the present petitioner and his own brother, the driver of the vehicle.
Yes,
So the petitioner number one was within that.
yes,
So that indicates something of the petition number
Yes.
one involvement, because few days prior to that, there was a heated argument between the victim
Yes.
and the arrested accused. So that's how it has been placed, and when the statements recorded under 164 CFPC by the eyewitnesses, they have also clarified. What will happen in the trial, we do not know. But what Mr. Azad has correctly said, that he was been, in the other case, there is a note in the case diary that he is also involved in a murder case. But in that case, he has been acquitted because of lack of.
That earlier case.
Yes, Mr.
Regarding
Wait, wait,
CDR, regarding CDR, if I may, Lordship may kindly turn to page 43.
Hmm.
Here, mobile numbers are mentioned here, and I have made a categorical statement that none of these mobile number belong to a petitioner number one.
But in the case record,
Lordship,
there is a specific note.
Lordship. Note regarding note, that is what I am submitting to Lordship, that they have also mentioned about charge sheet. They have not mentioned about judgment. So whatever is there, Lordship, I will face the trial, Lordship. Because none of these four numbers are mentioned, none of the mobile number belong to me. I have made categorical statement in my petition. If the IO has submitted any document.
For number two, we can consider, for number one, we appear. to seek bail.
Because Lordship, now investigation is completed.
Even when we think the ability, we do not know.
But whether his custodial inhibition will serve any purpose, because Lordship, now investigation, now one more thing your Lordship may kindly consider, that his first bail application was rejected on 28/6/2023, and after 14 days they submitted charge sheet, Lordship. So probably his custodial interrogation was not required at that moment.
Yes, Mr.
Because after going back the case, they immediately filed the charge sheet.
Charge sheet, that is their duty, they have done.
Yes,
We cannot
now he will face the
raise
trial.
question against investigation, my lord.
Page
They have
36.
completed the investigation, then submitted, my lord.
Yes. If investigation is complete, Lordship, therefore I am submitting, Lordship, that he will face the trial, whatever it is there, Lordship.
But he was shown absconder in the charge sheet.
Page 36, Lordship may kindly see that the date of charge sheet 12/7/2023.
Yes.
And his application was rejected 28/6/2023. That after going back the case diary, he immediately filed the charge sheet. So he also felt that his custodial interrogation is not required, Lordship. Otherwise, he would have made attempt to arrest him also, Lordship. If he is put behind bar, Lordship, he will not be able to defend himself properly, Lordship. Thus, I am handing over 2 copies of coordinate bench. Lordship also granted, but I forgot that judgment, Lordship. Lordship has allowed that application in 302 Tezpur case, but I forgot. Just I am coordinate bench I am handing over. Because after filing of charge sheet, Lordship was also of the view that whether he will face the trial or not, that part. I have given 2 copies, Lordship.
There is no bar. But it's depend upon merits of the case.
And after getting interim order, he also appeared before the IO during investigation, Lordship. That interim order, Lordship, I have enclosed here that your Lordship will find page.
Mr. Razak, let it come on third. We'll pass the order.
I got the information.
First, they want to rely upon some order.
Sarshit has submitted showing them absconder.
Sarsit has been suspended as an absconder, but it doesn't mean that he is declared as an absconder. Absconder can be considered only by the concerned court, not by the investigating officer.
After following provision of section 82, 83 and 87.
Yes, what do you have to say?
Lordship, can we read because paragraph 16? From this material and information, it is clear that the present appellant was not available for interrogation and investigation and was declared as absconder.
Yeah, but I have the statement.
Normally, when the accused is absconding and declared as a proclaimed offender, there's no question of granting extraordinary relief. We reiterate that when a person against whom a warrant has been issued and is absconding or concealing himself in order to avoid execution of warrant and declared as a proclaimed offender, in terms of section 82 of code, he is
Now-
not entitled.
This case is under section 82 of the CRPC, right? Where is the power? Who has the power to declare as an absconder?
Lordship, in the petition, Lordship, kindly, is number 49.
Forget this.
No, forget this. The
Who has the
question is
power?
under what
Do
section?
you have the CRPC?
Who
with
can-
you? You don't have. It's not the investigating officer. Our High Court has Justice H.N. Sharma's judgment. You read it at JLT or JLR, you know entire concept of section 82. How he has dealt with in that matter. There, the lordship has clarified who can be considered as an absconder. Even in the search sheet, if it is absconder, it is just a prayer, right? Only at the time of proceeding by the magistrate, it can when the leave will be issued. Doesn't appear then. Not at this stage. Filing a search sheet doesn't mean that the accused is he has committed the crime. We cannot punish somebody on the basis of the charge sheet. So similarly, 82 is a power of the court, not the power of the investigating officer. And here it court hasn't declared him as an absconder as of now.